No, no, don't ask me anything yet. Don't ask me anything yet. Hold on. Let your attorney speak for you. Mr. McLean, what's the announcement?
Negotiated plea, Your Honor.
Okay. Sir, what was your question?
The FTA is for the fair invasion and obstruction, right? Correct.
That is correct.
That is correct.
Thank you.
Okay. All right. Miss Allen? You're muted, Miss Allen.
Thank you. Position 19 is our case in chief. Position 20 is the failure to appear that will be null prosing today, and I'll submit that order to Ms. Strong. So 19 is 22 CR 003-648Y. The offer is for 2 counts. The first count is fair evasion. The second count is obstruction. It's credit for time served on both counts, 170 days, credit for 85 days. And that's it. There are no conditions. Does the defense stipulate to the facts and the evidence and venue?
We do so stipulate, yes.
Thank you.
And that was your understanding of the offer as well?
Yes.
All right. So, Mr. Husband, essentially the time you served in the Fulton County Jail will close your case. You wish to go forward, take a plea today?
Yes, ma'am.
Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange?
No.
And you're satisfied with your attorney's representation?
Yes, ma'am.
You understand by taking the plea today, you're giving up your right to trial by judge or jury?
I understand.
And you're giving up your right to have the state prove this charge against you beyond a reasonable doubt. And you understand that taking a guilty plea to these charges may affect other aspects of your life, such as employment, immigration, etc.
Yes, ma'am.
All right, as to the charge of fair evasion and obstruction, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or defense?
Nothing, Your Honor. Thank you.
All right, best of luck to you, sir. That concludes your cases.
Thank you.
All right, who do we have next?
Judge, we have a private attorney case for position 3, Mr. Brown. Wanted to know if he signed on.
Is the attorney, who is that attorney? Do we know the attorney's name?
Your Honor, when I spoke with Mr. Brown, he provided that her name is Jasmine Stewart.
Okay, is Ms. Stewart present? She is not. So we may have to reset that case.
Judge, are you ready for the probation calendar?
I am ready for the probation calendar. Thank you for your patience.
You're welcome. This is
All right, 5 and 6 on probation.
No, this is positions 9 through 12. Mr. Postel.
Okay, Mr. Postel, your cases are, let's see. Oh, one is a probation violation, which will have to be cleared. The case in chief, I believe, is 20 CR 005555J, in which you were charged with battery, family violence, and simple battery. And I think you also had 21 CR 007274J. In that case, you were charged with battery, family violence. All right, please raise, Officer Harris and Mr. Postel, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, Your Honor.
Yes, ma'am.
All right, you can put your hand down. Mr. Postel, what's going to happen is I'm going to listen to Officer Harris first to hear her recommendation as to how to resolve your violations. Then I'll hear from your attorney, all right? Okay. Officer Harris, please proceed with your recommendation here.
Yes, Your Honor. Probation recommendation is to give credit for time served to Mr. Postel. He has 54 days remaining on his case. He was to complete 12 weeks of anger management, and he failed to appear for the October the 4th hearing with Judge Benson.
Okay, I'm sorry, and your recommendation was to allow him to continue or to allow the time served to close his case?
Time served, Your Honor, for both cases.
Okay, and I'm assuming his attorney will not object to that. Ms. Adams, any objection to that?
No, there's no objection to time served, Your Honor.
All right.
But just for so the court knows, Mr. Postel is also on the SAP calendar as position number 32.
Okay. So I guess we'll take that one up now, but, so essentially, Mr. Pastel, what's gonna happen is the cases that you had in the past, the time you served in Fulton County Jail will close the cases and take care of those requirements, okay?
Okay.
And it will be reported as a probation violation, but otherwise, that's the end of those, okay? Let's now address 23 CR 006956J, in which Mr. Pastel is charged with giving false information. Is this a negotiated plea still?
Yes, Your Honor.
All right. Ms. Allen, can you please put the offer onto the record for me?
Yes, Your Honor, this is a time served offer. 4 days, credit for time served of 2 days.
Okay, I'm
Does it-
assuming that the defense will stipulate and has no problem with that recommendation.
Yes, Your Honor, that's correct.
All right, Mr. Pastel, you are still under oath. I've already sworn you in, so you are obligated to tell the truth. Are you under the influence of any drugs or alcohol at this time?
No,
Did anyone force you to take a plea?
no,
Are you satisfied with your attorney's representation?
yes,
You understand that by taking a guilty plea, you're giving up your right to trial by judge or jury,
yes, ma'am.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you further understand that the time you served in Fulton County Jail should close your cases.
Yes, ma'am.
And you also understand that taking a guilty plea may affect other aspects of your life, such as employment, immigration, etc.
Yes, ma'am.
All right. As to the charge of giving false name, how do you plead?
Yes.
I accept your guilty plea at this time. Is there anything additional?
Nothing from defense, Your Honor.
All right. Best of luck to you, sir. That concludes all of your cases.
This is also on the probation calendar, positions 5 and 6, Harriet.
All right. Okay. Hold on. I just did something and it went away. All right, Mr. Let's see, I'm sorry. All right, Mr. Harriot, your case in chief is 23 CR 003604Y, in which you were charged with DUI, reckless driving, and failure to maintain, as well as driving without a valid license back in May of 2019. You also have a probation violation. Officer Harris is still under oath, but I'm going to place you under oath. Please raise your right hand. Do you swear and affirm the testimony you give today to be the truth to the best of your knowledge?
Yes, Your Honor.
Oh, you were already under oath, Officer Harris. You didn't
Oh,
have to
sorry
do it
about that.
again. That's fine. Do you still agree, Mr. Harriot?
Yes, ma'am.
All right, you can put your hand down. You're right. What I'm gonna do is the same thing you just saw. I'm gonna hear from Officer Harris, then I'll hear from your attorney. Your recommendation, Officer Harris?
Yes, Your Honor. Mr. Harriet has 260 days remaining on probation. He was court-ordered to complete a risk reduction program, a victim impact panel, drug and alcohol evaluation, and 40 hours of community service, and pay a fine of $1,556.50. Again, we want to continue him on probation and to complete the evaluation within 30 days and to start the community service within 2 weeks upon his release from custody.
I agree with that. I'm inclined to, but I'll hear from Ms. Adams.
Your Honor, with regards to Mr. Harriet, there is no objection.
Okay, so what I'm gonna do, Mr. Harriet, I'm gonna report this as a violation. I'm gonna allow you to continue your probation. Please, you're receiving a second chance at this point. I need you to go ahead and comply. Within 2 weeks, you need to begin your community service. Within 48 hours of your release, I'm gonna require you report to probation so that you can get back on the right track, okay?
Ma'am.
All right. Best of luck to you. Please do what you're supposed to do, all right?
Yes, ma'am.
All right, take care. That concludes your case. Who do we have next?
Mr. Davidson, position 1 and 2 on the probation calendar.
All right, good morning, Mr. Davidson.
How are you?
You have 2 cases, but one is a violation. Our case that we're concerned with today is 19 CR 00116. I'm sorry, 1116Y. You're charged with failure to maintain possession of an open container, and DUI. Officer Harris is already under oath. She does not have to be sworn in, but please raise your right hand. Do you swear and affirm testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right. Officer Harris, your recommendation for how to resolve the violations?
Javier Postel Johnson.
No. We're waiting for Officer Harris.
My bad, I'm sorry. Yes, Mr. Davidson was court-ordered to complete a drug and alcohol evaluation, a risk reduction program, a victim impact panel, and for 240 hours of community service. He failed to appear on October the 25th with Judge Edie. He has 51 days remaining on his case. Probation recommendation is give him credit for time served to close his case.
All right, Mr. McLean, I'm assuming you don't have any objection to that.
That is correct, Your Honor. We do not.
All right, so essentially the time you've served there will close your case, sir, okay? Do you understand?
Yes, thank you, Your Honor.
All right, best of luck to you. Stay out of trouble, okay?
Thank you, Your Honor.
All right, who do we have next?
We're still waiting for position 3, Mr. Brown, for the private attorney.
They're not on the line.
And then the only case we have left in courtroom 2 is gonna be Mr. Hambrick. He's still on the phone with
Mr. Kelbach. Okay, we may have to, if Miss Stewart doesn't log on, we'll have to reset, unfortunately.
And I might mention, Your Honor, I do have a probation matter, Mr. Ashton Green. I've got a character witness who's on Zoom.
Is Mr. Green is not there though, is he?
No, he's not here yet.
Okay, well,
I just want to prioritize that.
can't do that one if he's not here. Okay,
What's it?
position 8, Mr. Fuses.
okay. Okay. Okay, so your case is 23 CR 006983A. You're charged with criminal trespass, obstruction, and 2 counts of committing certain acts that were prohibited in a rail or bus station. Do you understand your rights?
Yes, first.
All right. The announcement I have is negotiated plea. Is that still correct?
Yes, Your Honor.
All right. Can I have the offer put onto the record, either Ms. Allen or Ms. Kostadakis?
Yes, Your Honor. There's a conflict, written in.
Oh, okay. So this is not your case, Ms. Adams?
Your Honor, unless it was a typo, this is my case. I didn't see a conflict.
Okay,
Okay.
I'll proceed
That's
then. Okay, number 823 CR 006938A. See, the state's recommendation for count 1 is 12 months probation, served 32 days, credit for time served 16 days. He was booked 11/6/2023, balance probated. Stay away from Lakewood MARTA, located at 2020 Lee Street, Southwest Atlanta, Georgia. For count 2, 12 months probation, concurrent with count 1. Count 3, 12 months probation, balance probated, 40 hours community service, consecutive. I'm sorry, hold on. Concurrent with count 2, and then the count 4 is time served, Your Honor.
All right, Ms. Adams, was that your understanding and you can stipulate?
Yes, Your Honor.
All right, sir, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time? Are you satisfied with your attorney's representation?
Yes.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And you understand that by taking a plea, it may affect other aspects of your life, such as employment or immigration?
Yes, ma'am.
You understand the requirements that you cannot go back to the Lakewood MARTA station. You also have to complete 40 hours of community service. But by my calculation, you do not have additional time to serve at the Fulton County Jail. Do you understand all the requirements?
Yes, ma'am.
All right, as to the charges I previously listed, how do you plead?
No.
Oh, we didn't discuss a NOLO plea. Did the state object to a NOLO? You're muted.
Yes, Your Honor, one moment.
What's his history?
His history,
Yeah, we do good.
Well, let's
12
just see.
12 cycles, assault, 3rd degree, substantial bodily harm, assault, 3rd degree in 2008, domestic assault.
So the
Those
state, I'm assuming the state objects to the NOLO plea.
yes, Your Honor.
All right, if your client has to plead guilty, Ms. Adams, does he
Yes.
still want to plead guilty?
Yes, Your Honor.
All right, so we are going to require that you plead guilty. Sir, do you still plead guilty to this matter?
Yes.
All right, I accept your guilty plea. Is there anything additional?
Nothing further for defense, Your Honor.
All right, best of luck to you, sir. That concludes your case. Mr. Kelball, do you have an announcement?
I'm sorry, Your Honor. Yes, Your Honor, Mr. Hambrick, I would just say, Mr. Hambrick requests that I make a motion to dismiss the case for lack of evidence. I've explained to Mr. Hambrick that I don't believe Your Honor has the jurisdiction to dismiss the case for lack of evidence today at arraignment. If you could confirm that. for
I
Mr.
confirm, Mr. Kelball. That's correct. It will not be dismissed today.
Also, Your Honor, I wanted to inform the court that I have not yet received any discovery or police reports in the new matter, the 23 CR case. And finally, Mr. Hambrick does not wish to waive arraignment. So,
Okay. Will you waive a formal reading of it, Mr. Kelball?
I'm sorry?
Will you waive a formal reading of all the accusations?
Mr. Hambrick does not wish to waive anything.
Okay.
There's only one accusation.
Ms. Strong, my Odyssey is out. Will you please email me his accusations? I apologize. I've been trying to get on Odyssey all morning.
Okay.
So we're gonna have to come back to Mr. Hambrick since he won't waive even the readings. All right, let's go to the next position and we'll come back to you, Mr. Hambrick. All right.
We have position number 15.
All right, thank you.
Your
And
Honor.
are you?
Oh,
Yes.
I'm sorry. Number 15, my notes say it's a DA transfer.
Yes, right. I'm just gonna explain that to her. All right, you are Ramonte Harris?
Yes, ma'am.
All right. I'm sorry, sir. I apologize. Your case is 23 CR 006962Y. You're in this case, you're charged with fleeing and eluding, driving without a valid license, and theft by receiving. Your case has been transferred and accepted by the DA's office, is what my understanding is. So what happens today is there's nothing further for me to do. This is now out of my jurisdiction. Your attorney will be in contact with you, Mr. Harris, and will discuss next steps with you. But I did want to inform you that your case has been transferred, okay?
What you mean my case had been transferred?
Exactly what I just explained. Mr. McLean will come and talk to you at some point, all right?
Also, Your Honor, I did, after I got the email saying that the signature had been put on the paper, I did contact his family, so they are also informed.
All right, Mr. Harris, so someone will come, your attorney will come speak with you at some point to further explain the next steps, okay? But
I don't want him as my attorney, bro. I don't want him as my attorney, bro. I don't want him as my attorney. I'm gonna help.
Well, we're done here, okay? Good luck, Mr. Harris.
It will be
bro. Y'all folks acting like y'all crazy, bro. Nigga, mental health, bro. I don't want you as my attorney, bro. I don't like white people, bro. I don't like white people.
Well, we're done, sir. I think you should calm down. We're done. Best of luck to you. It's been a difficult day for defense attorneys, as I can see.
His family was very appreciative of it.
It's Thanksgiving, so I think
Yeah.
there's a lot of anxiety and stress today. All right, who do we have next?
Next we have position number 2 and 4, probation.
Oh, okay.
You're welcome.
So I'm sorry. 2 and 4.
I think that's gonna be Ashton Green, hopefully.
I'm sorry, 3 and 4, 3 and 4, I'm sorry.
That's okay. Give me one moment. I'm sorry. I'm working on my handheld as well. Okay, this is Ashton Green.
Correct, Your Honor, and on Zoom with us, if Ms.
Okay, let me read him his right before you tell me. You told me there's a character witness. I'm aware.
Right.
Mr. Green, your case in chief is 20 CR 003857E. You're charged with simple assault, family violence, and a probation violation. Officer Harris is already under oath. Please raise your right hand. Mr. Green, please raise your right hand. I'm going to swear you in. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury? Do you swear to tell the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Officer Harris, your recommendation to resolve his violation?
It's not even my probation.
Thank you. Please don't say anything. She's here to give me some information. You're muted, Officer Harris. I cannot hear you.
Oh, my apologies. I'm sorry. Yes, Mr. Green was sentenced on May the 2nd of this year to complete the 24-week domestic violence classes. As of today, Mr. Green has not reported to our office. He also got another offense of offensive theft by taking on August the 23rd of this year. He also failed to appear before Judge Morrison on October the 4th of this year. He has 197 days left on his case. Probation recommendation is to revoke that remaining balance.
Wow. Okay, Mr. McLean,
I need to have Mr. Bennett, Calvin, Angela Bennett, who's on Zoom there. We need to unmute the audio and get the screen going. So I'm trying to chat. Let's see. Please.
Is he just going to talk? What is he going to tell me about, Mr. McLean? I understand. You got to understand. I need to know what the substance of Mr. Bennett's testimony is going to be.
He's going to speak, I believe, on his community service, and he's the defendant has turned several things around and is active in community affairs and is trying to move society forward, and so he'd like to speak on that.
All right, very briefly, I'll allow it. Very briefly. That's unusual for a probation hearing.
Your Honor, Mr. Bennett has unmuted, and we just need to do the video now, I believe.
Mr. Bennett, very quickly, we have a large calendar today.
Yes, ma'am. I just wanted to say that
No,
over the past.
No, we have to be able to see you before you start talking.
My apologies, Dr.
All right.
Your Honor.
All right, go ahead. Well, let me swear you in. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, Your Honor.
All right, go ahead. Very quickly.
I just wanted to say that, I've had the privilege of working with Mr. Green over the past year, and he's helped with a couple of campaigns here in our city of South Fulton. He's did some work with some of our outreach programs we had, like giving back to the community on Community Day. And I just wanted to just stress to the honor that, he is trying to turn his life around and be a positive role model in our community.
All right, understood. Thank you, Mr. Bennett. I appreciate that. Mr. McLean?
Your Honor, the defendant tells me that he has turned several things around and is contributing on a regular basis now. He asked the court to consider not revoking the 197 days, but rather to give him either time served or the opportunity to finish the probation correctly as a continuation.
All right, Mr. McLean, it appears that he was supposed to appear twice. Does he have an explanation for why he failed to appear at probation both of those times?
We did discuss several matters, Your Honor, and one of those was he had a lot going on He had a couple of cases going on and thought mistakenly that he had fulfilled certain requirements, but at one point, I think the explanation was being overwhelmed. He's past that now, Your Honor. He's in much, much better stead. He's in much better shape.
All right. How much time did he have left, Officer Harris? Does he have
He
time
has
to
a hun-
complete I don't know. Does he have time to complete the requirements? If I did decide to allow him to continue?
He has 197 days. He should be able to have time to complete that 6 months course.
Right.
All right.
24
Right.
weeks is just shy of 6 months, Your Honor. So
All
he
right.
have time to complete.
All right, sir, I'm gonna, against my better judgment, allow you to continue on probation despite Officer Harris's recommendation. You have to report to probation within 24 hours of your release, and you must begin the requirements within 1 week of today. 1 week of your release, all right?
Excuse me, Your Honor, is he able to report on Monday? Because our office is closed.
Oh, that's
the
right,
rest of the remainder of
it's
this week.
Thanksgiving. Okay, so that's fine. You must report by Monday, okay? On Monday.
But you know, they do hold us into the like 2 extra days. If I'm not immediately released today, I can't be
Well,
still.
that's why I said we're giving you till Monday, okay? All right, so report on Monday, complete the requirements, all right?
Now,
All right,
and you know where to report, correct?
Yes, ma'am. Yes, sir.
Very good.
all right, best of luck to you. This is a second chance, don't mess this up this time. All
Yes,
right,
ma'am.
who do we have next?
We have position.
Hold on, I'm
position-
sorry, Gopi, give me 1 second. I just have a quick announcement. Are we
Okay.
doing position 3, Mr. Brown, or is that gonna be a reset?
I don't know, his attorney isn't here, I was gonna give them some more time to get here.
Okay, the remaining of the positions are gonna be done on the floor, Judge.
Okay,
Thank you.
all right. Who do we have at the iPhone?
Position 6, number 16.
Okay. All right, this is Lorenzo Harris Brown. All right, your case is 22 CR 001959Y. In this case, you're charged with loitering and prowling, obstruction, and possession of a pistol by someone who is under 18. You have a right to remain silent. You also have the right to an attorney, and this proceeding is being broadcast over the internet, and it's also being recorded. Do you understand all of that? All right, the announcement, Mr. McLean.
Your Honor, he would like the court to accept his guilty plea, but he feels that the 57 days that results from the calculation of math is more than is necessary to serve society's needs. He would like the court to consider time served on the jail portion of his sentence, or at least no more than 30 extra days. That would be if the sentence were, for example.
Wait, so this is a non-negotiated plea, Mr.
That is
McLean, is
correct.
what you're telling me? Okay, okay. So let's hear first from Ms. Allen.
Thank you, Your Honor. This is an incident from April of 2022. The defendant has 2 days of credit in this case. Officers responded to 95 8th Street on a report of suspicious males entering the parking deck. The caller and the remarks on the call document state that a few males on scooters with a mask just entered the parking garage, and there had been recent break-ins. And so these individuals were identified as possibly related to the recent break-ins and thefts from vehicles. Police began canvassing the area. They observed young man wearing all black on a bird scooter, observed that male traveling west on 8th Street and approaching 6th Street, and then down on the sidewalk, which is illegal. Upon seeing that violation, officers activated patrol and sirens. The young man saw officers and took off, jumping off the scooter and running up into a construction site at 859 Spring Street. He was apprehended. He began to jump down on the lower level of the construction area and continue through the site. Officers unholstered a taser, continued to give the defendant verbal commands to get down from the fence and stop running. he was taken into custody, I believe, without the use of the taser, but continued to arrest, not placing his hands behind his back. Eventually, he was able to be taken into custody and he was transported to a patrol vehicle to be searched, incident to arrest. Another person was also taken to custody.
What's his history, Miss Allen?
Yep. So this young man's date of birth, just for your information, is 12/11/2004. Arrest history includes 2001, 2002, and this case, I believe, 2003, theft by receiving in juvenile arrest, marijuana with intent, possession of a pistol by a person under 18, that was 2022, and fleeing and attempting to elude in 2023, which is actually separate from this case. He's got open Fulton County felony case, theft by receiving. He's got a $10,000 surety bond on that, as well as the 2023 case I mentioned previously.
Okay.
Possession of a pistol by a person under 18, and that's also a $10,000 surety bond.
Mr. McLean and Miss Allen, the calculation, I don't want to risk the calculation. He would have more than 90 days to serve. Is that correct?
The offer in this case, Your Honor, is a 12-month probated sentence with, let's see, credit for 3 days. Hold on.
Well, I have one is
120 days is what we're asking for.
Okay.
And so he's got credit for 3 days in this case.
All right, Mr. McLean, I will accept the state's recommendation if he wishes to go forward. Does your client still want to take this plea?
I discussed that with him earlier. Do you want further discussion about the numbers? And whether or not you want to go forward? Basically, Your Honor, I was saying that, you know, if it were 66 days, that would be time served. If it were 60 days to serve, that would be 27 to go.
Understood, but I'm accepting the state's recommendation if he goes forward. So do you want to speak, sir, do you want to speak to your attorney?
Want to talk to him before we go forward?
Only problem is I don't really want you going to a breakout because I would like to do Mr. Hambrick while we still have it. Is there some other way to speak to him?
He can call on 2392. It's 404-612-23.
Is there a way to call?
Yeah, he's on the phone.
Okay. So
Okay.
why don't you give him a call? We'll pause and we'll may come back to that one. Can Mr. Hambrick come back so that we can do that one? Thank you, Ms. Strong. I really appreciate you sending me that accusation. All right, Mr. Hambrick, I'm going to read your accusation in full. I will not be dismissing this case today. It reads as follows: in the case 21 CR 007424G. I, Keith E. Gammon, Solicitor General of the County of Fulton, State of Georgia, in the name and on behalf of citizens of Georgia, do hereby charge and accuse Sherman Tawan Hambrick Jr. with this offense, a simple battery, family violence, a misdemeanor for that said accused in the County of Fulton, State of Georgia, on or about November 7th, 2021, did intentionally make contact of an insulting and provoking nature with the person of Arkiana O'Neill, who is the other person living in the same household of the accused, by striking her in violation of OCGA Section 16-523F, contrary to the laws of the state, the good order and peace and dignity thereof. In light of that, I've just read you the accusation. That case has been formally accused by the Solicitor General of Fulton County, Georgia. You have 2 cases pending. The penalty for each of those could be up to 12 months in prison. They can run concurrently or consecutive, or a fine of $1,000. I've now arranged your case. The case at this time will be reset for a trial by judge or jury, depending on how we're going to put you on the jury calendar, but that does not necessarily mean you'll go to trial. Your attorney and you will continue to work on this matter as it goes forward. All right. Is there anything additional, Mr. Kelbaugh?
Your Honor, I believe you only arraigned him on the 21 CR case. Is that right?
Oh, he has 2. All right, Ms. Strong, I need the other accusation.
I can send it to you right now, and I'll send it to Mr. Kelbaugh as well.
I just sent it to you, Judge. I didn't realize he had 2 when we were asking. It should be coming through right this moment.
Okay.
I have a copy of the accusation. Thank you.
All right, normally I have Odyssey and there's no problem, but it's doing something interesting.
Did it come through yet, Judge?
Not yet. I'm refreshing fervently. I've got it now.
Okay.
All right, the other case is 20, I don't have the number for that one, but let's see, it's on the calendar. 23CR006822G. I, Keithy Jamish, Solicitor General of the County of Fulton, State of Georgia, in the name and on behalf of citizens of Georgia, do hereby charge and accuse Sherman Tawan Hambrick with the offense of battery family violence, a misdemeanor for that said accused in the County of Fulton, State of Georgia, on or about October 29th, 2023, did intentionally cause visible bodily harm, to wit, swelling to Shakayla Lightfoot, who is a parent of the same child of said accused, by striking her in violation of OCGA section 16-5-23.1 F2, contrary to the laws, the state, the good order, peace, and dignity thereof. I've already explained the implications. I've read your accusations. Your case is hereby arraigned and reset for jury trial. All right, Mr. Hambrick. Mr. Kelbaugh, anything additional?
No, Your Honor.
All right, case has been arraigned, will be reset for trial. Does that conclude your business, Mr. Kelbaugh?
Yes, Your Honor. May I be excused?
Yes, you may. Take care. And that concludes Mr. Hambrick's case. All right, back to the, could we have at jail court iPhone?
We have position number 31.
Is that that's not Mr. McLean's case, is it?
Which position?
No, Your Honor, it's not.
Okay.
31.
All right, sir, your case is 23CR006846Y. You're charged with battery. You have a right to remain silent. You have a right to an attorney, and this is broadcasting over the internet. You understand all of that? Do you understand, Mr. Phillips?
Yes, ma'am.
All right. The announcement that I have, what is the announcement?
Judge, this is going to be a non-negotiated plea.
All right. Is this Miss Allen? All right, Miss Allen, please proceed.
Your Honor, this is an incident from November the 1st of 2023. This is a battery. It's a domestic call. Victim was in the ICU with her grandmother, had a dispute with her longtime boyfriend because she refused to provide him with her laptop. He grabbed the laptop and threw it on the floor, grabbed her by her jacket, pulled her in front of the bathroom, refused to go into the bathroom, grabbed her by her jacket, dragged her outside of the location in front of the ICU, and punched her with closed fists on her face, causing her to fall to the floor. She was observed to have bleeding, and the defendant grabbed her and tried to take her into the bathroom. We would argue to hide her. Officers observed footage of the incident. The defendant is seen grabbing the victim by her jacket and dragging her and punching her twice in the face. She was observed by police also to have a cut on her lips. The arrest history in this case, or for this defendant, includes the 2020 ag assault, terroristic threats and acts, and false imprisonment in 2021, an open 2020 ag assault based on that arrest. Annie's on probation with the same victim for a 2022 false imprisonment and battery here in Fulton.
Okay.
The offer in this case, Your Honor, was 12 months probation, serve 120 days, credit for 20 days since 11/2/23. Balance probated, no further contact with Essence Dukes. Stay away from 1000 Johnson Ferry Road, which is Northside Hospital. No firearms, complete family violence intervention, and 40 hours of community service.
All right. Is Ms. Dukes present? Or wishes to make a statement? All right. Hearing and seeing none. Mr. Howard?
Yes, Judge. And let me tell you that Mr. Phillips, from our conversation from the very beginning, he was remorseful and willing to take responsibility for this. He was right off the bat that he knew that this was wrong and he wanted to resolve it. And there was no attempt on his part in any way to do anything other than accept responsibility for this. We'd ask the court to take that into account. He's a lifelong Georgia resident. He attended Stockbridge High School right in the metro Atlanta area. He does have two minor children, not with the other party in this case, I don't believe. But he does, he is court ordered to pay child support for those children. He was working at the McDonald's in Buckhead at the time of his arrest. He obviously is concerned about being able to maintain his employment so that he can continue to keep up with his financial obligations, including child support. And Judge, we are mindful of the case and mindful of the history, which is why we're asking the court to consider a 90-day sentence and as opposed to the 120. It means he would spend additional time in custody. And I don't believe it's a family violence case, so we'd ask that it be anger management as opposed to the FVIP. And aside from that, you know, we wouldn't have any issues with the other requirements and recommendations. So we'd ask the court to consider a lesser time. It means he would have to do additional time in custody, approximately another 25 days or so, if the court were to grant our request. The 90-day sentence is what we're requesting, Your Honor.
All right. All right, I will accept the defense's recommendation if he wishes to take the plea today. Does he still want to take the plea?
Yes, Judge. He was clear that he wanted to resolve this responsibility.
All right. And he understands the no contact, correct, Mr. Howard?
Yes, reiterate that, Mr. Phillips. No contact with the other party while you're on probation. No contact whatsoever. And that'll be a part of the probation. And if you violate that, then obviously that'll be a basis to try to revoke your probation. So just make sure that there's no contact whatsoever.
All right, sir, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
All right, you put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that taking a guilty plea to the charge of battery may affect employment, immigration, or other aspects of your life?
Yes.
And you understand the requirements. I'm requiring you to serve approximately 25 additional days in the Fulton County Jail. Upon release, you're going to take anger management. I believe, Mr. Howard, you requested 6 weeks or 8 weeks?
6 would be fine with us, Judge.
And
No,
Your
I know it
Honor,
would be
this
fine
is,
with you. I'm
this
sorry, go
is
ahead.
family violence. I'm not sure why it's not specifically noted on the accusation, but Miss Essence Dukes is a girlfriend and they were living together. So I can amend that now.
Well, Judge, we dispute that. It's not our understanding that they were living together.
Well, then it sounds like this isn't a guilty plea.
Well, it sounds like you didn't accuse it as a family violence battery.
That's
Okay.
exactly what I just said. And I'm going to
So we're gonna
re-accuse it if
proceed
that's
to
what we
vote
need to
that,
do.
but we
He's
ask
got an
the-
open felony case against her as well.
Still doesn't change the fact that they don't live together.
Is Miss Dukes? Miss Dukes is not on the line?
No, she's not. Struck her in the face, said it was her boyfriend whom she lived with. She was then escorted to the emergency room. How are they related? How did they know each other?
But
Okay, if he takes his plea, I am going to require the FVIP class.
Thank you.
So does he still want to take it?
I believe so, Judge. We obviously discussed all the options. But
Okay.
yeah,
I'm going to require the FVIP course. All right, so I did, okay, so he's gonna take the family violence intervention program and complete 40 hours of community service. You understand all those requirements, sir?
Ma'am, they just threw me off. Can you repeat it one more time? I'm sorry.
Okay, so you're gonna have about 25 additional days served Fulton County Jail. You cannot have any contact with Ms. Dukes. You're gonna stay away from the hospital on Northside, you're gonna stay away from Northside Hospital unless you're getting medical help or attention. You're not gonna have any firearms whatsoever. You're gonna stay away. I already said that. You're gonna complete a family violence intervention program and complete 40 hours of community service. You understand all of that?
Yes, ma'am.
And you agree to complete those requirements?
Yes, ma'am.
All right, as to the charge of battery, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional?
Can we go back through the time one more time, please, Judge? So he's
20
getting
days, he's serving 90 days.
90
90 days.
credit for 20?
Credit for 20.
Okay, thank you.
Yes.
All right. Is there anything additional?
Mr. Phillips, what, I mean, is it something that you and I need to discuss, or you have a question about? I mean, we can discuss after.
It's okay, thank you.
Yeah.
All right. Best of
I'll
luck
file
to you.
down an amended accusation now.
Well, Judge, we plead to the battery, not battery family violence. He's accepted the responsibility. He's taken the evidence.
I mean, I guess I didn't think the
Evidence
law
is-
was like a gotcha situation, really, but
Not a
okay.
gotcha. It's your responsibility, not ours, to accuse the case.
Okay, we're
We don't
gonna
have any
move on.
proof other than
We're done. We're gonna move on. We got a lot to do, and all of us are moving forward. Understood on both sides, you all. Thank you both for your advocacy. All right, who do we have next?
For Mr. Harris Brown, are we going into a breakout session with him?
Okay, was Mr. Harris Brown be able to speak to Mr. McLean?
Your Honor, we're now in a courtroom that has no inmates in it, so we can do a
But
break.
the problem is we can't do anything else.
Correct.
Is the issue. That's what I don't want to do.
Do some
Is there
laptop.
any other way to, for Miss, do you have a laptop?
Yeah,
Can-
yeah.
Laptops, we have two of them here.
Your Honor, my laptop is on, it's PD Samantha Adams. You're more than welcome.
Okay, can Mr. McLean go into a breakout with Miss Adams's laptop? And then we can do somebody at ACDC.
Your Honor, good morning.
Good morning.
Position 17, Alexis Henry.
All right, that's not Mr. McLean's position. is it?
It is,
Then-
Your Honor, she's a waiver of presence and arraignment.
Okay,
We have a written version that I've emailed it to myself, and I will forward it to the court and the clerk and everybody.
so are we being heard on bond?
No, Your Honor, that's just simply a waiver of presence and arraignment. She did not wish to be heard on bond.
Okay, so you're entering a formal waiver, just to be clear, Mr. McLean?
Yes, Your Honor.
Okay, so Miss Henry, there's really nothing to do today. I'll speak to her and let her know that. In the meantime, are we gonna go to the laptop, Mr. McLean?
Yes, Your Honor.
Yes, Judge, Mr. McLean, Ms. Adams' laptop, and who else?
And jail court iPhone.
Okay, thank you.
After that, there's a plea with Monique Jones.
Okay, hopefully we can do something that's Miss McLeod. Is there a number for Miss McLeod to give whoever she needs to speak with a call?
Good
Is she
morning.
Good morning, Miss McLeod. Is Miss Duval at ACDC?
Yes, Your Honor, but I have not brought her up yet. I wanted to do the three ladies first, and then I'll go down to the fourth floor to get Ms. Duval and 6 Northeast for Mr. Rucker.
That's fine. I'm here. No problem.
Okay, so for Miss Henry, is Miss Henry there? I'll tell her what's
Yes.
happening. Okay, Miss Henry, your case is 23 CR 006949Y. Your attorney has entered some forms and is resetting your case for trial at this time. That does not necessarily mean you'll go to trial. It means that there's some additional work to do on your case. Your attorney will be in touch with you and let you know what's happening from there, okay? So there's nothing we're gonna take care of today, okay? All right, best of luck to you, Miss Henry. Who else is there at ACDC?
I have position 7 on the probation revocation calendar. Cassandra Hunter.
All right, is that Mr. Howard or Miss Adams? I'm hoping.
Adams, I believe.
Okay, that works out. All right, Miss. Okay, Miss Hunter, you have a probation violation. You are also here on your case in chief 21 CR 004515F. In which you're charged with battery, family violence, cruelty to children in the 3rd degree, 2 counts. You have a right to remain silent. You have a right to an attorney. And this proceeding is broadcast over the internet. You understand your rights and how I'm conducting this today?
Yes, understand.
All right. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Thank you. Officer Harris, your recommendation?
Judge, I don't mean to interrupt, but she's Mrs. Watson Cafe's client. Is she on? Zakia Watson Cafe?
Oh, she's not any of you all's. No, she's not. Okay, and I'm assuming this is not Miss McLeod's case. We may have to reset.
Right, Ms. Watson Cafe is one of the other conflict attorneys. Yeah.
Okay.
I don't know, Mr. Jordan, or anybody's on who can maybe reach out.
I
to-
was gonna ask if so, is there someone who can maybe give Miss Strong, will you give Miss Watson Cafe a call if possible?
Sure.
Thank you. If not, we have to reset to Thursday. And there is no Thursday.
Oh, yeah, right.
We have to reset. All right, we're gonna see if we can get your attorney on the line, okay?
Okay, I wrote a letter for your honor. Should I wait to
No.
speak to the attorney
No,
first?
yes, please don't present me with anything without your attorney being present.
Okay, all right.
Thank you.
I
All
apologize.
right.
What's the client's name? I'm sorry, Judge Williams.
She is Hunter. She's on probation calendar.
Okay.
Position 7 and 8, the
Okay.
Cassandra Hunter. All right, who do we have next? Is there someone else we can do at ACDC?
Your honor, the only one that I have left is Monique Jones, which is Mr. McLean's client.
Okay. Is Mr. Howard, is Miss Jones a plea?
Let me see if I can figure out what the announcement was for you. So you got the
Yeah.
announcement, right? What number is she on the calendar?
She's 25.
It is gonna be a negotiated plea, Judge. I guess we
This
could.
is a plea we attempted to take last week.
Oh, okay.
So
So yeah, we probably need to wait on Mr. McLean since he spoke with her more recently. To make sure everything,
well, we can't take that.
that we could hold a fee for that.
Okay. Well, there's nothing we can do.
Your honor, I do have an announcement on position number 5. He's gonna be a reset. Our social worker has met with him. They are working on getting him into the rescue mission of Macon. He's actually been accepted, but they're waiting for a bed. And so we'd like to reset him to the 11:30 calendar.
Okay, and I don't have any objection to that, so we'll reset that. Are there other announcements?
Yes, Judge, I have an announcement on position. Let's see. Position.
Wait, so position number 5 is being reset to 11:30, not 11:28?
Right,
They're-
11:30 would probably be better.
They're requesting 11:30. Is there room on 11:30?
Yes, ma'am. I was just going off of what was on the announcements. That's why I asked. Thank you.
Okay. Thank you for checking. All right, any other announcements?
Yes, Judge, position 40, Mr. Thomas Sherrod, I actually was taken up to try to, because he wouldn't come down yesterday, and they took me up to the cell. We're asking that he be reset to the 11:30 competency calendar. It looks like an eval was already requested for him back on November, recently, November 8th, I believe it was requested. So
Okay.
we just as asked, we reset the next Thursday's competency calendar.
Okay. So reset. All right, Mr. McLeod. I'm sorry, Mr. McLeod. Mr. McLean, do you have an announcement?
Your Honor, bond is moot in this case. We asked to go to plead not guilty. We will wait for formal reading of the accusation. And if you just tell him that maximum punishment is 12 months and $1,000 bond on each count, and tell him to watch out for his court date, that'll constitute the arraignment.
All right, Mr. Harris Brown, at this time, your case will be reset for trial. At that trial, you will not have the burden to prove the charges against you. The state will bear that burden. If they do meet that burden, you can face a sentence of up to $1,000 fine or 12 months in prison, and it can run concurrent or consecutively. I have hereby arranged your case. You've entered a not guilty plea through your attorney. Your attorney and you will stay in contact and do additional work on this matter, okay? All right, best of luck to you. That concludes your case at this time.
Thank you, Your Honor.
All right, now let's go to Ms. Jones. Ms. Jones, your case is 23 CR 006776Y, in which you're charged with criminal trespass. It's my understanding that this is a negotiated plea. We attempted to take this plea last week. Does your client wish to take the plea, Mr. McLean?
Your Honor, she tells me that she does. There are two cases, Your Honor. One involves restitution, one does not.
Okay.
I pleaded guilty.
All right. Well, we're gonna go through this case, this criminal trespass case. All right. Ms. Casadakis, is this yours? Or this is Ms. Allen. Ms. Allen, please proceed.
Thank you, Your Honor. So position 24 and 25 on our docket. Are we talking about the offers on both cases, Mr. McLean? I was confused.
Yes, she is accepting the offers on both cases, and one of her main concerns is she needs help on housing. As soon as she is released from the jail, we ask her to come to our public defender office and speak with our social work staff who will help her find housing.
Are you disputing the restitution, Mr. McLean?
She's going to do her best, Your Honor. If she can get a job to pay the restitution, all a person can do when they're on probation, pay restitution is the best they can. She's going to try.
Okay. All right, Ms. Allen?
Yep. On position number 24, that's 23 CR 006776Y, one count of criminal trespass from October the 28th of 2023. The offer is credit for time served 4 days. And that's it, no conditions. Position number 25 is 23 CR 006827Y. This is an incident from October the 31st of this year. The victim is Merida, MERIDA, and Daryl, DARYL, last name Gadson, GADSON. They are requesting and have provided documentation of restitution for $599.08. The offer in this case is a 12-month probated sentence with credit for the 22 days she's been in jail, balance probated, and no contact with the victims, as well as paying that restitution.
And that was your understanding, Mr. McLean, and you stipulate to the 3 elements as it pertains to both cases?
That is correct, Your Honor. It is our understanding. We do so stipulate.
All right, Ms. Jones, I'm going to ask you some questions to see if this is voluntary. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury? Is that a yes? I need you to speak loudly.
Yes.
All right. Are you under the influence of any drugs or alcohol at this time?
No.
You can put your hand down. Thank you. Are you satisfied with your attorney's representation?
Okay, yeah.
Did anyone force you to take a plea?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
All right. Do you understand you're giving up your right to trial by judge or jury?
I'm pleading guilty.
Right. But do you understand that you're giving up your right to a trial? You have a right to a trial and you're giving that up. Do you understand?
No, I want a trial.
Okay. We attempted to take this plea last week. We're not going to take this plea. I'm going to arraign her case and then we're going to reset not guilty. This is, I don't know. I don't think she really wants to take the plea, Mr. McLean. Okay, so at this time in case 23 CR 006776Y, the defendant is charged with criminal trespass, and 23 CR 006827Y, defendant is charged with criminal trespass and damage to property. Do you waive a formal reading of the accusation, Mr. McLean?
We do waive the formal reading, Your Honor. We have copies. We've gone over them.
All right. Ms. Jones, at this time, I'm resetting your case for trial. At that trial, the state will bear the burden to prove the charges against you beyond a reasonable doubt. If they meet that burden, you could face a sentence of up to 1 year in prison or a fine of $1,000 for each charge. Based upon this information and your request for a trial, I'm accepting a not guilty plea from you at this time, and your case will be reset.
I didn't plead not guilty.
You told me you want a trial, so I'm setting your case for trial. All right? The case will be set for trial at this time. All right. Best of luck to you. Your attorney will be in touch with you further, Mr. All right, who do we have next?
Position 43, Well.
Your Honor,
Yeah.
I may have a brief moment with regards to position number 5, Mr. Michael Chanel. I just requested a reset, but while you were taking the last plea, I received a call from a social worker where Mr. Chanel has actually been accepted. He has a bed. They said the bed will be available on Monday. So we'd like to enter a not guilty plea. So I just wanted to update the court. We can take that after Mr. Howard is finished. But we would like to do a bond hearing as well, so that he can be released to the custody of the rescue mission Macon.
Okay. All right. I'm sorry, what position was this? 43?
43, Well.
Okay, Mr. Webb, your case is 23 CR 006955E. In this case, you're charged with battery. You have a right to remain silent. You have a right to an attorney, and I'm conducting this proceeding over the internet. You understand your rights? Please unmute him.
Yes, ma'am. Yes, ma'am.
All right, and the announcement?
Judge, this is going to be a non-negotiated plea as well.
All right. Is this Ms. Casadakis?
Yes, Your Honor.
Please proceed.
All right. Does defense stipulate to the factual basis, Your Honor?
We do.
Oh, they do? Okay.
Yes.
Okay, the state's recommendation is 12 months probation, serve 180 days, credit for time served 15 days. He was booked 11/7/2023, balance probated, 12 weeks of anger awareness, and a no contact with Corey, Corey Anderson, and a MHET. And that's the state's recommendation, Your Honor.
Okay. Can I have his history? This is non-negotiated.
Yes, Your Honor. His history is 42 total cycles, prior convictions, more than 10 probation violations, 2015 forgery, 2015 DC DeKalb, 2015 theft by shoplifting, 2017 ag assault reduced to terroristic threat, 2018 DUI from Woodstock, 2018 simple battery, 2019 giving false name, 2019 theft by taking simple assault, 2022 theft by taking Cobb, 2022 theft by shoplifting Marietta, 2023
I think that's sufficient. Okay. I'm sounding for Corey Anderson at this time. If Corey Anderson is present and wishes to make a statement. Okay, I saw someone with that name earlier. I no longer see that name. All right, Mr. Howard, please proceed.
Judge, and speaking of Mr. Webb, he is a lifelong Georgia resident. His family lives in Marietta. He attended Marietta and graduated from Marietta High School. At the time of his arrest, he was working. He's been working as a cashier at Dollar Tree, and he obviously is hopeful that he'll be able to. He believes he can get that job back once he is released from custody. Judge, I didn't hear a long history of violence. I did hear a number of cycles, but in speaking with Mr. Webb, we believe that alcohol played a part in this case, which is why we're asking the court to consider a nolo contendere plea. And we would ask the court to consider a sentence of 60 days as opposed to the 180 days that the state is requesting. Mr. Webb has been in custody 15 days, so that means he would be in jail an additional 15 days or so if the court accepted the defense's recommendation. But we would ask the court to take into account his lack of a long history of violence. And we do believe that this was an incident where alcohol contributed to his behavior, and he was remorseful for that. And we'd ask the court to assess, instead of a MHET, an alcohol drug evaluation. He's fine with the anger management, but we believe an alcohol drug evaluation might be more appropriate given what we know.
All right, I need to hear I know the facts were stipulated too, but can I have the facts as alleged?
Yes, Your Honor. September 6, 2023, just making sure I'm not muted. Okay. September 6, 2023, officers were dispatched to 1161 Ponce de Leon Avenue. Upon arrival, officers spoke with Miss Corey Anderson, the victim, who stated that she was walking down the sidewalk going southbound on Moreland Avenue on the side of Exxon when the defendant was walking on the same side but going northbound. She stated that when we passed each other, the male just punched her in the face out of nowhere with a soda can. Defendant had open warrant out of APD.
Mr. Howard, if we take this plea today, I am going to accept the state's recommendation. Does your client wish to go forward and take the plea?
Mr. Webb, the state, as you hear, the court is going to go with their recommendation if we accept the plea today. Now, as we discussed, we can not accept that and do a not guilty plea and push the case forward. Otherwise, it would be an 180-day sentence, meaning you have to serve 90 days in custody. So roughly another 75 days in custody if you accept it, the plea offer today. So do you want to do that, or do we want to maintain a not guilty plea and move forward? He's on mute.
No, I think I'd rather do the not guilty.
Okay, all right. So Judge, we'll do a written waiver and do a not guilty plea and ask that it be reset on a jail jury count.
All right, the case will be so reset. Best of luck to you, Mr. Webb.
Thank you, Judge.
All right, that concludes his case. What do we have next?
I just got position 44. Can I ask one question? Your Honor, can I ask one question?
Mr. Webb,
yes,
good question you and I need to discuss.
Right. Do I just have do I have a future where you're going to come see me, or I come to court? Okay. Okay.
Yes.
So I'll have a future court date.
Yes. Yes.
Okay. Thank you. I'll just wait to see you, sir.
Okay. All right.
Thank you. Thank you. I appreciate it.
All right, Mr. Wilkes,
Yes,
I have information that your case has been transferred to the DA's office, 23 CR 006966B. I no longer have jurisdiction to address this case. So at some point, your attorney will come talk to you about this matter. The case has been upgraded, okay?
Judge, and I guess at the time, so that I'm assuming the transfer order has already been submitted.
I believe so, yeah.
And Judge, I will say, I'm hopeful that in a formal way, this will be formalized, but I would argue that the court still has jurisdiction until the case receives a CP number or some type of indication that has been actually accused or indicted in Superior Court, that is still within the court's purview to address this issue. We actually had a meeting with Judge McBurney about the transfer cases about a week and a half ago, and this issue came up. There was no resolution, but I
understand your position, but I don't want to be the one who when there's been no handing down in directions. The directions I have now, that is, if it's been accepted, there's not much I can do. I'm sure that there will be further robust discussions, and I am inclined to agree with you, Mr. Howard, but those are not the instructions I have today. So,
thank you.
Okay.
I apologize. What position was this, number 44?
Yes.
Thank you.
All right. So, Mr. Wilkes, best of luck to you. Your attorney will speak to you soon.
All right.
But I agree, Mr. Howard. That's not where we are right now with things.
Thank you, Judge.
All right. Next case, position 2.
All right. Mr. Darian Bodie, your case is 22 CR 003691J. You're charged with simple battery. You have a right to remain silent. You have a right to an attorney. And I am broadcasting this over the internet. You understand your rights?
Your mouth.
What is the announcement?
Your Honor, the situation with Mr. Bodie is he is only being held on the FTA, which is not on the calendar. And so the reason why I wanted to address that is because, he's willing to take a plea for position number 2, but the FTA has not made it to the calendar. So I wanted to make sure that was addressed. The reason why he missed court is because he was actually incarcerated somewhere else. I believe it was in Gwinnett County, if I'm not mistaken. And so I wanted to see whether or not we could just address the FTA. If not, then he'd be willing to go ahead and take a plea in order to get the FTA null crossed. But again, there's no case number on here for an FTA, but he does have one because there's a $2,000 bond on it.
Okay, so he's made bond on, well, he FTA'd, so that's what happened. Okay, understood.
Mr. Gordon is looking into that right now. I'm sorry, Judge Williams, I didn't mean to cut you off.
No, that's fine. That's more than fine. Okay, so you're saying that if the FTA is resolved or he can make bond on that, you don't want him to take the plea, Ms. Adams? Is that what you're?
He's willing to take the plea, Your Honor. So, but if we can resolve the FTA, he would like to just maintain his not guilty in his, because he does have a bond on the case that is on the calendar. I mean, it's a signature bond, or he's bonded out on that charge. It's not keeping him here.
Okay. I'm not sure what the correct posture is. So he wants to plead not guilty. Because normally if he took the plea, the state would null pros the FTA.
Yes.
But he wants to plead not guilty, but he did fail to appear.
Yes, and if
essentially that signature bond got revoked and reinstated, correct? Is that is that the correct posture of what happened?
Mostly, Your Honor, the bond on the case is on the calendar. He still is out on that bond. That is not keeping him here.
Okay. Oh, so he has an FTA on something else.
No, Your Honor, there is an FTA on this, but when you look in Odyssey, it doesn't appear that the FTA revoked his bond. The bond that he has for $2,000.
Can we just hold tight for a second on that one, please, while we look into it?
The problem is, do we have anybody else at Fort North to do?
Yes, we got a little left.
Okay, so we'll come back to him. Thank you, Ms. Strong. That's a good suggestion.
Mr. Jordan is right here, Judge Williams, I'm sorry.
So Judge, he failed to appear on the CR case, which resulted in the FTA warrant. So the warrant hold is for the same CR case. That's
what I was thinking.
FTA case number.
So he technically has a $2,000 bond on the case that appears on this calendar because he FTA'd.
Correct. I just forgot to create the FTA case number.
Okay, so he has a $2,000 bond. So you want to have a bond hearing?
No, Your Honor, if that's the case and it was just missed, then he'll just go ahead and enter take the negotiated plea.
Okay, so let's go back to Mr. Bodie. He wants to take the plea. All right, Ms. Allen or Ms. Kostadakis, is yours?
Yes, Your Honor, it's mine.
All right, please put the offer onto the record.
Yes, case number 22CR003691J. The defendant made physical contact of an insulting nature with a minor BW by punching him several times in the face with a closed fist. The victim is a minor. The state's recommendation is 12 months probation, serve 14 days, credit for time served 9 days. He was booked 11/15/2023. Let's see. Balance probated, 8 weeks of anchor management, no further contact with the minor BW, and whenever it's proper, Your Honor, we can sound for the minor.
Or the parents of the minor. Are the parents of the minor present on this Zoom conference? Last name Wade. All right. Ms. Adams, do you stipulate to factual basis, ID, and venue, or was that your understanding of the offer?
Yes, Your Honor, we do stipulate. I just wanted to add one thing. For the record, Mr. Bodie was, this incident occurred at a juvenile detention center. Mr. Bodie also was a minor at the time. So I just wanted to let the court know that. And so other than that, Your Honor, we are ready to proceed.
All right. Mr. Bodie, please raise your right hand. Do you swear and affirm testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
You understand that by taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand that you have to take 8 weeks of anger management and have no contact with that person. Initials BW.
Yeah, ma'am.
All right. As to the charge of simple battery, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional?
Not from defense, Your Honor.
Not from
All
the
right.
city.
Best of luck to you. That concludes your case.
I go
What do
home.
we have? I'm sorry, Mr. Bodie.
I go home today.
If you don't have any other holds, this case is no longer holding you in, okay?
All
right, best of luck to you. Who do we have next?
right, position 26.
That's fine. Your Honor, on position 26, I had noticed it would be advised, are we in mute? No, we're not. I had noted that it would be advisable to have a social worker conversation with him before taking the actual plea.
Okay. Do you wish to reset this case?
Oh, no, Your Honor, we don't want to reset. We don't want to reset it. A pause for a few minutes if we could just speak to him. The social worker is here.
Okay. Is there another position we can do at 4 North? Well, then you would have to put 4 North. There wouldn't be anything else we could do.
We could go into a breakout room, and
But all the other people are at 4 North. Well, no, that's not true. He's at jail court iPhone. Is that correct?
I believe he's on.
Okay, so if courtroom 2, if we could use the laptop and put Miss Adams' laptop in with 4 North, I'll take whoever is at jail court iPhone. Who do we have at jail court iPhone?
We have position number, what your name is, I'm sorry. What's your name?
Humphrey, man.
Okay, we have Mr. Humphrey, position number 18.
Position number, I'm sorry. 18.
Position 18, number 18.
Who
Yes.
represents Mr. Humphrey?
That's Mr. McLean.
Is it Mr. McLean?
Yes, Your Honor.
Oh, this case has been transferred as well.
Position number 18.
Okay. 18 has been transferred. Okay, so we're gonna put 4 North in with Miss
Adams.
Adams's laptop.
Okay, thank you, Judge.
Thank you. Okay, Mr. Humphrey, your case has been transferred to the DA's office at this time. So what that means is that there's nothing that I can do at this point regarding your case. Your attorney is going to come talk to you and discuss next steps, okay? So one of your attorneys will come out and speak to you about how your case is going forward from here, Mr. Humphrey. All right? Are they frozen?
It appears so.
No, you,
We can't hear. Did Mr. Humphrey hear me?
say
Yes.
All right. So your case will be reset. You'll get a new court date and your attorney will come speak with you. Best of luck to you. All right. Who do we have next?
Next, we have position number 41.
Position number what?
40.
41. I'm sorry, it's breaking up very badly. All right.
I'm sorry. Yes, position number 40.
All right, Mr. Smith, your case is 23 CR 006935J. In this case, you're charged with battery and criminal trespass. You have a right to remain silent. You also have a right to an attorney, and I'm conducting this proceeding over the internet. Do you understand your rights?
Yes, I do, Your Honor.
All right, thank you. The announcement that before we do this, who represents this defendant?
I do, Judge.
All right, wonderful. Glad that worked out. I have that this is a non-negotiated plea.
That is correct, Your Honor.
All right. Ms. Kasadakis?
Yes, Your Honor. Does the defense stipulate to venue, factual basis, and ID?
Yes.
All right. The state's recommendation for count 1 is 12 months probation, served 90 days, credit for time served 19 days. He was booked 11/3/2023. No further contact with Victoria Taylor. Stay away from 2585 Beerler Drive, Atlanta. No firearms. Restitution open for 30 days. The restitution, the victim said it would be around $300 for her damaged clothes and an FVIP. For count 2, 12 months probation, consecutive to count 1. Same conditions, no further contact with Victoria Taylor, stay away from the same address, no firearms. And that's the state's recommendation, Your Honor.
Okay. The factual basis briefly, Ms. Casadakis.
Yes, Your Honor. One moment.
First, man.
Let's see here. The officer responded to an incident for injuries from a dispute. The caller victim advised she was assaulted by her roommate, the defendant. Officer spoke with the victim, who stated the apartment belonged to the defendant and that she was his roommate. She stated that she found the apartment listed on Craigslist. She advised the defendant called her job asking for $150. She stated that she spoke with the defendant about calling her job about the $150. The defendant said, "You're going to give me the $150 or get out today." The victim stated the defendant then placed his forearm on her face, pinning her on the bed. Victim stated she screamed for him to get off her. Victim stated while waiting for a 911 operator, Mr. Smith hit her in the face, proceeded to go into the bathroom to get hand soap and threw it around her bedroom. Defendant then went back into the bedroom to get the liquid bleach and threw it around her bedroom and her clothes. Victim stated she tried to take the bleach bottle away from him, which caused the bleach liquid to spray on the floor. Officer spoke with a female witness who was inside the apartment during the incident. The witness stated that she came to the apartment with the defendant. The witness stated heard yelling coming from the bedroom and went to see what's going on. And so the defendant pushed the victim and hit her in the face. At one point, pinned her on the ground. The witness stated the victim was screaming for the defendant to get off her. Witness also stated that she saw the defendant throw bleach around and that she tried to get in between them, but the defendant was too strong. While talking to the victim, officer noticed bruises on the left and right cheek of her face and lacerations. Walking through the apartment, officer could smell the strong odor of liquid bleach, with the odor also burning my eyes. Officer observed the liquid trail on the floor leading to the living room, to the first bedroom on the right, which belonged to the defendant, then the second bedroom to the right belonging to the victim. That's all, Your Honor.
All right, I'm sounding for Ms. Taylor. Is she present? Wishes make a statement? And the defendant's history, Ms. Casadakis?
Yes, Your Honor. Let's see, 20 total cycles. Battery, family violence, conviction, 12 months probation. And the rest were, that's all we wrote down for the conviction, Your Honor.
Okay, Mr. Howard?
Yes, Judge. Mr. Smith is 40 years old. He too has lived here in the metro Atlanta area for the past, actually he's been here for the past pretty much all his life, but he lived with his mother up until 11 years ago. But he's still been living here in the metro Atlanta area. He is disabled. He does receive monthly income related to that disability. And part of the concern with the jail time is if he's in custody more than 30 days, that those funds will be cut off. Of course, he uses that to pay for his rent and any other daily needs that he may have. Judge, this was more of a landlord type dispute. We would characterize it that way. They were not in a relationship or anything along those lines. It's my understanding she was there for a very short period of time, about 15 days, about two weeks or so before the incident arose where the money was at issue. Judge, we would ask the court to consider 12 months served, 38 days, credit for the 19 days, so that he can be released on probation, so that he doesn't lose his income related to his disability, and he can start whatever classes. And we would ask the court to consider, given the lack of an intimate relationship and the short period of time that they were in the same space, the court would consider anger management as opposed to FDIP. Obviously, I think the spirit of the law is for intimate partners, people who are living together in a sense that they might have a relationship. So we'd ask the court to consider that. Also, the restitution, if there's not a defined amount at this point, Judge, we'd ask that not be a part of the requirements and recommendation. Obviously, there are other avenues to pursue if there are any damages that the other party may have. So we'd ask that there be no restitution if the state doesn't have proof, any documentation here today that we could agree to on an amount, because who knows, we have no idea what. We heard a number today, but we don't have any proof or any documentation to support.
We have pictures, Your Honor, if the court needs them.
Okay.
I'm talking about in terms of a monetary amount. We don't have any documentation about what it costs or what it may cost today. So we would ask the court that the restitution requirement be deleted.
Okay. If he takes, I'm sorry, go ahead, Mr. Howard.
Sorry, Judge, the state is asking for a two-year consecutive probation. We don't believe that's appropriate. We would ask that it be concurrent on the second charge rather than having 2 years of probation. I did hear that there may be one other conviction for violence, but outside of that, I didn't hear a long history of violence that would support 2 years of probation on this, Judge. So we'd ask the court to consider that.
So a simple search in Odyssey shows at least 5 prior battery cases in this gentleman's history. He's currently on probation.
All right. If he takes
on a battery here.
If he takes the plea today, I am going to accept the state's recommendation, Mr. Howard. Does he wish to go forward?
Ms. Smith, we talked about it. There's going to go to state's recommendation, which will be the 90 days. Do you want to go ahead and do the plea, or do you want to do it not guilty? He's muted.
Yes, I'm sorry.
I said the judge is going to go with the state's recommendation if you do a plea today. So do you want to accept the 90 days, or do you want to plead not guilty and push the case to a trial counsel?
No, I would not be willing to accept that. They will have to show in trial valid proof of as to why.
So we're gonna stop talking. Okay. So what we're gonna do is we're gonna reset the case. Mr. Howard, will you enter a waiver of arraignment?
A written waiver, Judge.
All right. So we'll set the case for can Mrs. Smith. Best of luck to you.
Thank you, Judge.
All right. Who do we have next?
We can go back to Love Lady 26.
I'm sorry, what we can go back to where?
Excuse me, Your Honor.
Mr. Smith, if you have questions, if they can call 2392, I'll certainly answer any questions you have right now. You can talk to me.
All right, Mr.
No, I was wanting to accept the plea.
What was that?
Said I was wanting to accept it's loud in here.
I can't hear what's happening. You want to take the plea if I accept the state's recommendation?
Please, I want this over as soon as it's possible and for them to prove what they've done to me. What would be my out date, if I may ask?
Mr. Smith, you're getting credit for 19 days. You would serve approximately 45 days. So you're looking at maybe another 26 days in custody.
You'd serve 52 days additional.
52, yeah, no, 20. It will be 45 days. Half of 2 for 1, 45-day sentence. He served 19, so there'll be an additional 26 days.
Your Honor, which position?
All right, additional 26
is this?
Okay, I'm willing.
We're still on Mr. Smith.
Position 41.
So he wants to take the plea?
Mr. Smith, we did talk about it at length, but are you sure? We talked about both options.
Yes. So far as the probation, how does that run? Is it concurrent or is it consecutive?
Do you want to speak to him, Mr. Howard, so we can keep?
Sure.
Okay. Is there a number he can call?
I'm sorry. Loud.
Right, the 612-2392, they can call me at that number. And Judge, I might understand it would even all the requirements and conditions that the state is asking, it'll be exactly as the state is requesting, or just the jail time.
It will be exactly as the state has requested, Mr. Howard.
All right, so yes, you can call me at 2392, we'll talk further. Or if you want to do a breakout with my laptop, we can do that as well.
Can we do the breakout on the laptop? It doesn't matter either way. All right, we're back to Mr. Lovelace. Mr. McLean, what is the announcement now?
Your Honor, that is a plea. It's a fairly simple plea. It's time served, balance suspended, 3 counts.
Excuse me, Judge, so it's the laptop, Ms. Adams' laptop and jail court's iPhone?
Actually,
Yes.
you can do mine, you can do Derek.
Mr. Howard. Mr.
Okay,
Howard.
then, thank you.
All right, so we'll go back to Mr. Lovelace. Ms. Kostadakis, or is this Ms. Allen?
Okay, Your Honor.
Ms. Allen, please proceed. Put the offer onto the record for me, if you don't mind.
Yes, of course. So this is 3 charges on position number 26, Corey Lovelace. Disorderly conduct, impersonating an officer, and obstruction. We're asking for the service of 6 days, and he gets credit for 3 days. So that means credit for time served, balance suspended. Stay away from the WellStar Urgent Care at 1170 Cleveland Avenue in East Point. And these are all 3 counts are concurrent. So it's a 12-month probationary period that is suspended and a stay away order.
All right. Mr. McLean, was that your understanding of the offer, and do you stipulate to the 3 elements?
We do so stipulate, it is our understanding. I explained to him that place is gone by many names, but whatever hospital it's called, he will stay away.
All right.
Whatever name it's called, he'll stay away.
All right, Mr. Lovelace, please raise your right hand. Do you swear in the front testimony you get to say will be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Did anyone force you to take a plea?
No.
Do you understand by taking a plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand that you cannot return to the WellStar Urgent Care?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment or immigration?
Yes, ma'am.
All right, as to the charges of disorderly conduct, impersonating a public officer, and obstruction, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from state or defense?
Nothing, Your Honor, thank you.
All right, best of luck to you, sir. That concludes your case. Who do we have next?
Hey, Miss Cam, I got who's coming to the phone.
Is there anyone else we can take?
Judge, everybody's on the medical floor, so it's gonna be the jail court iPhone or medical.
Okay, understood. Thank you.
Your Honor, since we're here, I can file a waiver of appearance for Mr. Chanel, position number 5. This is the one that we originally reset, but while in court, we have received notice that the Fed will be ready for him on Monday. So we'd like to change it to a not guilty and a bond request.
Okay. All right, so before we do that one, is there there's no other positions in the jail? What about at ACDC? Nobody we can take at ACDC? Okay, I see Mr. Shaw for the bench warrant calendar is on the line. Who represents Mr. Shaw?
Your Honor, that would be Mr. Howard.
Okay, Mr. Howard, and he's talking to someone, so Mr. Shaw has to hold. I'm sorry, I couldn't hear at ACDC. Was that you, Milton? I didn't hear the announcement.
Can you repeat that? I can't hear you.
Okay. I guess we can do the wave pay. I'm sorry. What was the announcement? I couldn't hear you.
Okay, Your Honor, give me a few minutes, please. Okay?
Okay. I understand. It's like a lot of moving parts today. All right, we'll do the Wade case in which Ms. Adams is requesting a bond hearing. Defendant, Mr. Chanel, has been charged with simple assault and 2 counts of obstruction in 23 CR 006828G. Is this Ms. Allen? Or Ms.
Kasdakis.
Ms. Kasdakis, what is the current bond and the state's position regarding bonds?
Your Honor, the current bond is 500 on each count, on each of the 4 counts. The state's recommendation, the state believes that the bond as set is fair and reasonable, so.
Okay, and so there's some program that has accepted him, Ms. Adams, and you wish for him to be able to go to that program on a signature bond?
Yes, Your Honor, to be released to their custody, so he would be dropped off there, so it wouldn't be him going on his own. The name of the program is called Rescue Mission Macon. They offer housing, jobs, they help give people jobs. They do classes, which include classes for substance abuse, anger management, and coping. They also outsource for some of their mental health, people. Now with regards to Mr. Chanel, he's a 27-year-old man. He's originally from Columbus, Georgia. He's born and raised right here in the state of Georgia. He had only been in Atlanta for a short period of time. And he has had various jobs. Last job he had was working at a chicken plant. So with regards to that, Your Honor, we are requesting that he have a signature bond so that he can be released to Rescue Mission Macon, and we could order a transport to get him there.
Okay, I will grant the signature bond. I will convert the current surety to signature through the jail on the condition he's released to that program directly with the conditions that already applied. What were the conditions?
The conditions, Your Honor, are, let's see, they are to stay away from MARTA 2424 Piedmont Road, 20 hours community service, and a $300 fine.
Okay.
Those are all.
Okay, so I mean the conditions of the bond conditions were to stay away from any, I guess there were no conditions. Who was the alleged victim in that case?
That was a no further contact, Judge, with Officer C. Craig and abide by MARTA suspension. Yeah.
Okay, so those same conditions will apply to the SOB to the jail.
And BHET as well, I'm sorry.
And I think he just did the BH, so we don't have, okay, understood. Thank you, Ms. Strong. So that takes care of that position.
Thank you, Your Honor.
Thank you.
You have their number?
And I apologize, who is he being released to?
It's Rescue Mission Macon of Middle Georgia.
Okay.
And I'll go ahead and prepare the transport order.
Can you put the name in the chat, please, if you can?
Absolutely.
All right, any other positions we can go to? Can we mute it, courtroom two?
Yes.
Thank you.
Your Honor?
Yeah.
I'm gonna have Ms. Hunter come and take the seat. Ms. Hunter? Come on up, have a seat. Would you let her know about Attorney Watson Cafe, please?
Oh, she's not here. We have to reset her case. I'm sorry, Ms. Hunter. There's not much we can do. I have to reset. What is the next available calendar that I could set her on?
It can be Tuesday.
Okay, I have to unfortunately reset her to Tuesday because your attorney has not appeared and you need to have representation since she's already entered. We attempted to reach Ms. Watson Cafe, but we could not. So we are resetting that case, okay? So we will reset your case to the earliest available calendar, which is Tuesday. Okay, Ms. Hunter? I can't understand. I can't hear
I'm
Ms.
sorry,
Hunter.
I have her on mute.
Will she be aware of Tuesday, or do I have to make her aware?
I can't answer that. If you can try to give her a call too, we'll continue to try to reach her, and I'm going to ask someone to send her an email as well so that she is aware of that day. Okay.
Okay, how can I reach her? This is my last question.
I don't have that information either, but I will ask staff here at the court to make Ms. Watson Cafe aware and send her an email, okay? Thank you, best of luck, and I apologize for that.
Your Honor, Attorney McLeod is speaking to her she should be logging on now.
Okay, understood, thank you. All right, is Mr. Howard still on the phone?
He is still on, the breakout, Your Honor. I mean, in the breakout.
In the breakout room, okay.
Your Honor, I do have a quick question with regards to, position number, I believe it was position number 3, Mr. Terrell Brown. He's represented by private counsel as well. I believe her name
Is Jasmine Stewart. I guess he's gonna have to be reset as well.
Yes, Your
I
Honor.
do not, and a prior protective order was dropped from the same person. So-
All right, who's sitting at ACDC?
This is Mr. Rucker, Charles Rucker, position 33 through 39.
Is that, who represents Mr. Rucker?
I do, Your Honor.
All right, and your announcement, Ms. McLeod?
Mr. Ruckers indicated that he would like to accept the state's offer to resolve all 5 of his cases.
All right, understood. Ms. Allen, is this you? All right, please proceed. You're unmuted. Oh, you're unmuted now. Thank you.
Thank you, Your Honor. Good morning, Ms. McLeod.
Good morning.
So Mr. Rucker is position 33, 34, 35, 36, 37, and 38 on our docket. They are in chronological order on the docket. Position number 33 is a 12-month probated sentence or offer with service of 30 days. Stay away from Circle K at 3601 Flat Shoals Road in Union City. Position number 34, same 12 months probation, serve 30 days, balance suspended. This is the stay away from the BP gas station at 4350 State Route 138 in Union City. 33 and 34 positions, there's no credit for any time served. Position number 35, 12-month probated sentence, serve 30 days, balance suspended and stay away from Infinity of Union City at 4201. State Route 138. Again, there's no credit for any time on that case. That's position number 35. Number 36 is a null pros. I'll go ahead and submit that order in a few minutes. That's 23 CR 003019A. Number 37, 12-month probations, serve 30 days, balance suspended, and stay away from the park at Netherly, NETHERLY. That's 6770 Buffington Road, BUFFINGTON, and that's in Union City. Again, no credit for time on that case. Position 38 is 2 counts, 12 months probated, serve 30 days, balance suspended, and stay away from the Days Inn at 6743 Shannon Parkway in Union City. And the second charge is concurrent. And again, no credit for time. Position number 39, same sentence, concurrent on 2 counts, 12 months, probated, serve 30 days, balance suspended, and stay away from parks at Netherly again, 6770 Bluffington Road in Union City.
All right, Ms. McLeod, was that your understanding of the offer? And you stipulate to the factual basis, ID, and venue?
We do, Your Honor.
All right. Mr. Rucker, I'm going to ask some questions to make sure this is a voluntary plea. Will you please raise your right hand? Do you swear and affirm testimony you give today will be the truth to the best of your knowledge under the penalty of perjury? He's muted. We can't hear him.
Charles, speak up a little louder so the judge can hear you.
All right. Do you swear and affirm that you will tell the truth today?
Say it a little louder so she can hear you. You can do it. I know you can. Come on. Come on, Charles. Come on. Give me.
Are you sure he wants to take this plea, Ms. McLeod?
He does, Your Honor, and I spoke to him. He, for some reason, he has a bit of a problem speaking up loudly. We had the same issue last week, but he does want to take the plea.
Okay. I'm assuming you're going to tell the truth, sir? Is that a yes?
Sit down, sit down, sit down. Speak and speak real loud so she can hear you. You want to go home to the seat? Oh, she's a nice judge. Come on, you can do it. She's not gonna hurt you. Say it loud.
I was able to hear him on the phone. Go ahead, Mr. Rucker, speak up.
Do you want to take this plea, Mr. Rucker? You're not sure?
He said yes, yes.
Yes? Okay, Ms. McLeod, would a bond hearing be more appropriate? Would you, I understand that he has a lot of cases, but I'm not sure he wants to take this plea.
Bond hearing would be fine, Your Honor. He actually does want to take the plea, and I spoke to him about speaking up loudly, but for some reason he seemed to freeze up when he's before the court.
I understand, but I have to make sure this is voluntary.
I understand, Your Honor.
Do you wish to take a plea? I'm gonna ask you one more time, Mr. Rucker. You want to take a plea? And do you promise to tell the truth?
Yeah.
Okay, we're gonna arrange. Ms. McLeod, will you enter a formal? Has he already been arranged?
I believe so, Your Honor.
Okay, I don't want to.
Honestly, not.
All right, so I'm gonna arrange his cases anyway,
Yes,
just
that
to
would
make
be the
sure. Mr. Rucker, you have several cases today. The state has read them. 23 CR 003016A, 23 CR 003017A, 23 CR 003018A, 23 CR 003019A, and 23 CR 003020A. In these cases, you're charged with criminal trespass, and 2 of them loitering and prowling, and you have 1 with disorderly conduct and obstruction. At this time, I'm arraigning your case, which means that I've made you aware of your charges. Ms. McLeod, do you waive a formal reading of the accusation?
We do, Your Honor.
All right. Based upon that waiver, at this time, your case will be reset for trial, Mr. Rucker. That does not mean that you're going to trial necessarily. It means that you and your attorney will continue to work on this matter to see if there's something we can do to resolve it. At that trial, the state will bear the burden to prove the charges against you. If they meet their burden, you could face a sentence of up to 1 year in prison or a fine of $1,000 for each charge. What is the current bond on each of these cases?
One moment, Your Honor.
And I'm assuming what's happening in each of these cases is he's just returning to places he should not be.
Yes, that's my understanding.
Ms. McLeod, when you spoke with him, was he able to understand that he should not return to those locations?
He was, Your Honor.
Is anyone from pretrial on the line? Ms.
Yes,
Tyson,
yes.
Ms. Tyson, can you give me his history, please?
Yes, Mr. Rick, he has 26 arrest cycles in Georgia beginning in 2007. Within the last 10 years, he has a felony conviction out of Clayton County for state county guidelines with weapons, intoxicants, drugs without consent, marijuana possession less than 1 ounce, and that was from October 2014. He has a misdemeanor conviction out of Fulton for battery, family violence, first offense. That's from November 2017. It looks like he has a pending case out of Jonesboro, and that's for misdemeanor theft by, and he was arrested February 2022 for that case. He has a misdemeanor theft by shoplifting conviction out of Clayton from 2022. A criminal trespass out of DeKalb in 2022. And his last arrest was in Chamblee, April of 2023, and that was for willful obstruction. And he does
That's
have
sufficient. That's sufficient. Thank you, Ms. Tyson. I got the
You're welcome.
flavor. Ms.
Your
Allen.
Honor, it's not that he stays or is present some place where he's been asked to leave. There are different facts in each of these scenarios, and he is able to speak to people on the scene when these happen. So he walked up to the manager of a store in position number 33 and said people were trying to kill him. He was barricaded actually in the office and wouldn't leave. He appeared to be under the influence. On position number 34, he was located in the store at the BP. He took a 6-pack of beer, went to the bathroom and consumed some of the beverages. He told police he'd consumed cocaine earlier in the day and was happy to pay for the beer. He was given a trespass warning at that time. In 35, he was on video surveillance at the Infinity car dealership going into vehicles on the lot. He exited the lot through a hole that had been made in the fence and sat on the pavement, and it was reported that he sleeps inside of the vehicles when he can get inside of them. Position number 33, the residential location. He is sleeping in the laundry room on one of the washing machines, and had locked the door so others couldn't get inside. He refused to open the door, but eventually opened the door. On position number 37, same facts. Position number 38, this is the Days Inn. Suspicious person standing at the entrance.
Can I go to a breakout with Ms. Allen and Ms. McLeod?
I'd appreciate that. Thank you.
Please.
Ms. Allen, Ms. McLeod, and just you?
Yes.
Okay.
Attorney Howard, can you call me at 8114, please?
Yeah.
Jail course iPhone?
No, this is Milton. Can you call
No,
me
no,
back?
I'm speaking of jail course iPhone. I'm trying to find, do they have Justin Hampton on 3 South? Jail course iPhone. Look like they froze. Sarge,
Sorry, what was that?
do you have Justin Hampton there? On 3 South?
Justin, he's not even on the list.
This is
Oh,
Hampton.
yeah, he is. No, we don't have him yet. We don't have him yet.
You don't have him up there?
Yeah, we don't have him. We don't have him over here yet. He'll be the next person that we pull.
Oh, okay, because we're gonna need to, Samantha Adams is gonna need to break out with him. Anyway, we could, well, I guess we gotta do, we can do this first. Let's plead with Mr. Smith first. But she'll need to break out with him. They told her she was alone out to Chatham County. Justin Hampton yesterday when she tried to see him. But he's there on 3 South, is what you're saying.
Excuse me, Mr. Howard, Judge wants you in the breakout room with them.
Oh, okay, all right.
Okay.
Hey girl, what you got up here?
So you can put me in, Mr. Gray.
One dash 3. I got 1 dash 1.
Why would I? I wasn't here. No. It didn't even know
And Mr. William Shaw,
2 dash 3.
yes. I've left you several messages and sent you an email. Did you get my email?
I haven't got no email or no messages, sir.
I put
Well,
there
the number on the form, and I called in and left you a couple of messages. But can you call
I mean, the 2.
612?
Hold on right quick.
Well, there are no phones available right now, so we'll have to.
Okay, I'm listening. I'm listening.
Yeah, we'll have to come back to it because there are no phones available right now.
Oh, okay. But I was just letting you know that I was currently locked up from September.
Mr. Shaw, Mr. Shaw,
15th.
Mr. Shaw, don't talk about your case right now because it's still in court. You're gonna have to wait to speak to Mr. Howard, okay?
Okay, ma'am.
No, I just see straight. I mean, right now I haven't get nothing I'm working on. And 500, a lot. Yeah, a lot.
Oh, wow.
I'm sorry.
You want me to leave the meeting?
Yeah.
Okay, Mr. Rucker, your case is being reset to next Thursday. Your attorney is gonna talk to you and some people are gonna come explain to you why I've set your case on that calendar, and they're gonna help come up with a plan for you, okay? So when your attorney gives you a call, she's gonna explain everything to you and your case will take place from there, all right? All right, so that concludes your case. Best of luck to you, Mr. Rucker. All
Your
right.
Honor, Your Honor, can we please do Ms. Duval? Larcenia Duval, please?
Yeah.
Could we also do that in a breakout room?
Okay, so if we can go back to Ms. Duval. Let me at least read her rights. Ms. Duval, come forward. Ms. Duval, are you hearing me?
Ms.
Walk up.
Duval, hold on.
Walk up quickly, Ms. Duval. Your case is 23 CR 006435F. You're charged with battery, family violence, and simple battery, family violence. Do you understand your rights? You
Good
understand
morning.
Good morning. You understand your rights?
I want to join the
No,
program.
no. You don't
Come
want
on,
to do
right.
anything.
Who
You have a right.
I'm talking to?
You're talking to
Miss
the judge.
McLeod.
You have a right to remain silent. I'm here. You have a right to remain silent. You have a right to an attorney. That's all I want to hear. Do you understand those rights?
Okay, do I talk to my attorney first?
No, you talking to me for a second. Do you understand your right?
Who are you?
I'm the judge. Do you understand your rights?
She got to go to which calendar first?
Do you understand your rights? Okay, we're gonna go into a breakout room. If I could go on with Ms. McLeod, is this Ms. Kostakis? If Ms. Allen wants to come, I'm sure she's welcome. And we'll figure out what's happening.
Yes, please. Thank you.
My baby was on.
Who do I talk to? Who do I talk to?
Calm down.
Who is you? What do you want? Stepmother, what do you want?
Ms. Grace, can you put me in a breakout with William Shaw? Eric Howard.
I'm sorry, Mr. Howard, you in the breakout with who now?
Hey, William Shaw.
Where's, William Shaw, okay, no problem.
All right.
Just leave a message on her voice,
I don't have a confession to make. Yes, I hit her with 2 sticks, but I didn't hit him. Don't touch me. He ran from me. I haven't been on me confession. He ran a lot to me. Called him on me. He told me to come back. I he could come back. And she come back to me. He called him on me. He gonna have me in jail with family so he could sneak in and touch on me. This nigga messing. Yeah. I told you to take on a shower when I came in. Thank you.
Okay, Ms. Duval, some additional steps are going to be taken on your case. We are not going to resolve it today. Your attorney is gonna come back out and speak with you, and some additional procedures will be put in place.
Who is
So
my
we're-
attorney? She
your
don't come out. She never came out the first time.
Okay, well, she's gonna
Miss
speak
McLeod
with you.
didn't come to booth 8 and 4NE at 102. I'm
Okay.
at Garnett Atlantic Detention Center by the
Yes,
Garnett
yes, I
Greyhound Station.
understand. I understand. We're gonna
Not at
reset-
Wright Street.
All right, we're resetting your case. And your attorney will come and speak with you before your next court date, okay?
Well, excuse me, Your Honor.
Yes.
Is it possible that her attorney could call me also?
Miss McLeod, I'm sorry, who are you, Miss Brown?
I'm her mother.
Okay, Miss McLeod, if you would chat an
Yes.
email or a number for Miss Brown to give you a call,
Oh,
okay?
absolutely.
All right, so her
Is it-
attorney
is
is
it-
Miss
who
McLeod.
do I talk to
Her
today?
attorney is on the screen, and if you'll chat her, Miss Brown, a good phone number. Don't send it to everybody. Scroll through the chat and send it to Miss McLeod, okay?
Yes,
All right,
ma'am. I'm sending her my number right now, Your Honor.
Thank you. All right, Ms. Duval, best of luck to you. Your case is gonna be reset and your
No,
attorney's
hold
gonna
on.
speak to your
She's gonna-
family.
Come out to the program.
Your Honor, may we be excused, please?
Yes,
Thank
you may. Take care. Thank you. Have a good holiday.
And I ain't get my medicine in here.
Okay. All right. Is there another position we can take? We're going back to Mr. Smith.
Yes, can we go back to Mr. Smith?
Is Mr. Howard here?
Mr. Howard is in the breakout room with the bench warrant DV case. He should be back momentarily. I know that I was waiting to find out whether or not you guys have Justin Hampton. I think he said he's gonna go get him next. And I also still have another person named, those are the two positions I still have left. That is position 1 and position.
Are there any positions at the jail that will, let's do it this way. Are there positions at the jail that will not be brought today that we're aware of?
Yes, Your Honor, there are. One moment.
Well, not the ones that you requested not to come, but the ones where they're not gonna be able to get them to bring them out. Like I know you still have quite a few left. 170, I could go through. We're missing about 10 positions. Of those 10 positions that remain, are there any that are refusing or that won't be brought? Okay, so we're still holding on 1. We're gonna have to reset position 3, I believe. Holding on 10, 11, 14, 23, 28, 29, 42, 40. And that's all the ones I have. As well.
Your Honor, 42 should be a DAX transfer. Ward.
Okay.
And I was just told that Justin Hampton was released.
Okay. Thank you.
I'm sorry, Your Honor. And number 40, Sherrod, that was reset to 11:30, I believe.
Okay, thank you. Oh, you're right. I have that one scratched through.
What did we say on position 42? I missed it. I apologize.
We're holding on 42.
Yeah, 42 should be a DAX transfer, DA transfer.
But I think they still have to be brought so I can tell them that.
Yes, Your Honor.
Who do we have at? We don't have anybody.
I apologize. For these cases that are being transferred to Superior Court, are you all sending over orders to me for them to be transferred?
I believe those orders have already been submitted by Ms. Falk, but I can forward you the email that has those orders in them.
Maybe so. I'll look if they
Okay.
have. Maybe I overlooked it. I just want to.
Absolutely. I'll do whatever you need.
I have 23 was released as well. Does everyone else have that?
Who was the person that the officer said was released?
That was.
He said it was Hampton, I think.
That was
Hampton.
Yeah,
Justin Hampton?
Yeah.
Number
He's position
14.
14.
Is 23 released as well? Oh, no.
Yes,
Okay.
sir.
23 started.
He believes.
Okay. All right. And we are on hold for Mr. Howard.
No. No.
Okay, Mr. Howard, your announcement.
Yes, Judge. Mr. Smith would like to accept the plea.
Okay. All right, so we've gone through the conditions and we're just asking him the question. Mrs. Smith, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
I do, Your Honor.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
Unfortunately, no.
Are you satisfied with your attorney's representation?
Yes, very much so. He done his best due diligence.
Did anyone promise you anything in exchange for taking a plea?
Again, unfortunately not.
Did anyone force you to take a plea?
Absolutely not.
All right, and you understand the requirements of the sentence as explained to your attorney?
Yes, I do, Your Honor, but he has some additional information about that, if you may.
All right. And you also understand that taking a guilty plea may affect your ability to it may affect employment, immigration, probation, and other things that I cannot anticipate.
Yes, I'm aware of that, Your Honor.
And you further understand you're giving up your right to trial by judge or jury.
Yes, I do, Your Honor.
All right. As to the charge of battery and criminal trespass, how do you plead, Mrs. Smith?
Unfortunately, guilty. I have no other option.
Well, you do have another option. You could go to trial. Do you wish to plead guilty or do you wish to go to trial?
I wish to plead so that I can get back to my freedom as soon as possible.
All right. Mr. Howard, you had some additional requests according to your client?
Yes, Judge. The only additional thing, a couple of additional things. We're not sure of the status of Ms. Taylor. I don't know if the state has any information about whether she is still living at that address or if she's moved. Obviously, this was a dispute about rent, so I don't know if does the state have any insight on that? Because that'll affect our request as it relates to being able to go to that address.
I don't have that information, Your Honor.
We do have an estimate for the damage at this point, as well as the photographs with her clothing that was damaged by all the bleach, and it's $300. So if that's something that's amenable at this point for the restitution issue, I will now inquire and get specifics about her residential status.
Okay, yeah, we could do that because he would either be asking to go back if she's not there, obviously, and if she is remaining there, then he'd ask for a one-time escort with law enforcement to retrieve his things. Obviously, he would have a number of things to retrieve, so he'd need a window of time that would be sufficient to do that, probably at least a few hours. And Judge, the additional thing he was referring to was he's actually planning had already put wheels in motion to move out of state. He'd already cleared it with his other probation officer. We would ask that if he completes that he would be able to do phone in, mail in, or report by Zoom if he moves out of state as he intends to. And other than that, we'd ask that once he completes the requirements and conditions that probation be allowed to go non-reporting.
Okay, as to reporting by Zoom, I don't have any objection to that if probation is able to do that. I don't think that I don't have any qualms about that. As to the return to that location, what we'll do is he can return with law enforcement one time to determine whether or not she's there. If she's there, he must stay away. If she's not there, he can return.
And
Does that address all the concerns?
Mrs. Smith, what is your question?
I just had two things to say. I'm sorry. As far as the restitution and damages, I read the police report, and in the police report, it stated that only socks was damaged, and that the police officer did witness that. I'm not sure that any pair of socks could correlate to $300 worth of damage. And also, I am the main and sole leasee on that apartment. Had been there for 5 years. Again, she was just a tenant who's been there only 14 days. So as far as her staying there, I'm not even really sure lawfully she could, because it's my apartment. But that's all I wanted to add.
Well, yeah, Mrs. Smith, you and I discussed that that's a legal issue as far as eviction and things of that nature, and that's separate from the court's proceeding and what it requires.
Okay.
But the restitution is going to be 300. Either you're comfortable with that or you're not. Potentially, I mean, it could be. That's the number I floated to you earlier that they gave us. So I don't know if she's claiming there was more than that damage, but the plea involves you accepting to the responsibility to pay the restitution, and we're hearing it could be around 300. So I don't know if that's a deal breaker for you or not. But if it's not,
on limited income as well. I don't financially feasibly.
So he does not want to take the plea.
Yeah.
Are we undoing it?
Mrs. Smith, I told you it's all or none. We got to remember, it's all or none.
Thank you all for listening to me. I appreciate it. I know y'all very busy. I'm sorry.
We appreciate your patience today, Mr. Smith. And best of luck to you. I'm accepting it as the guilty plea with the conditions and the request that Mr. Howard has made. Ms. Strong has a question.
Thank you. So
I'll be out by December 17th, correct? At the latest.
If things go according to how the jail normally does, 2 for 1, you can expect to be released around that time. But it's ultimately up to the jail to give 2 for 1.
All right. Thank you. Thank you so much.
So I'm sorry, Mr. Howard. Is the restitution now $300, or are you all waiting to get more information?
I thought we were leaving it open. Are we leaving it open?
That's what I was asking.
I would say let's just handle it at $300, Your Honor.
Okay. Miss Allen, are you the prosecutor for this case?
Miss Casadakis is?
No,
that's me.
Okay, whomever. Could one of you all put the information for the
I sure will.
in the chat, please, so I can put it on the thank you. Thank you, Judge.
Okay. All right. Best of luck to all concerned. That concludes your case, Mr. Smith. Thank you.
Thank you, Your Honor.
All right, Mr. Howard, can we do the DV bench warrant case?
Yes, there's one piece of information I'm trying to verify on Mr. Shaw. I've been trying to reach him since yesterday, and I was able to speak with him in a breakout just a little bit ago, and so yes, just we can address it. I'm trying to confirm some information. He tells me that he was in custody in Whitfield County from September the 15th until October the 28th, which would cover the date that he missed court. And I was trying to, when I had a second, to call Whitfield County to confirm that. So other than that, Judge, if the court would like proof of that, then we can, if you could hold, and I can try to get some confirmation from Whitfield about that.
Okay. Yes, I guess we can hold. We'll take the medical case while you look for that, Mr. Howard.
I'll make that call now, Judge.
All right. Who do we have at medical?
We have position number 1.
Okay. Mr. Beasley, your case is 23 CR 005805E. You're charged with criminal trespass. You have a right to remain silent. You have a right to an attorney. And I'm conducting this over the internet. Do you understand your rights and how I'm conducting the hearing today?
Yes, ma'am.
All right. The announcement I have is negotiated plea.
Yes, Your Honor.
All right. Ms. Allen, I get this wrong every time. Ms.
Oh, it's okay.
Costa,
Yes, next.
please put the offer onto the record for me.
Yes, Your Honor, the defendant stood in front of the CVS and kept entering and picking up bags of chips and cursing out the employee there. The state's recommendation is 12 months probation, served 6 days, credit for time served 3 days. He was balanced, suspended. Stay away from the CVS at 2350 Cheshire Bridge Road, Atlanta, Georgia.
All right, Ms. Adams, was that your understanding? Do you stipulate to the 3 elements?
Yes, Your Honor, for both questions.
Okay. All right. I'm gonna ask you some questions, Mr. Beasley. Raise your right hand.
Oh, I'm so sorry. I'm so sorry, Your Honor. I'm so sorry, Your Honor. The defendant
Oh, he
also
has other cases. I'm
Yes.
sorry. Did
Yes,
did that same offer apply to those open cases as well?
One moment. Defendant has open cases 23CR004695E criminal trespass. That's going to be the 12-month probation, served 4 days, credit for time served 2, balance suspended, stay away from Lenox Mall at 3393 Peachtree Road, Atlanta. And then count 2, obstruction to law enforcement officers. That's going to be 12 months probation, serve 4 days, credit for time served 2 days, balance suspended, concurrent offer on both cases are global.
All right, that was your understanding, Ms. Adams?
Yes, Your Honor.
All right, Mr. Beasley, do you swear and affirm testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. All right, are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone, are you satisfied with your attorney's representation?
Very much.
All right. Do you understand the requirements that you can't go back to that location? Otherwise, the time you serve should close out your case. And those locations are that CVS and I believe it's Lenox Mall as well.
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment and probation, immigration, anything like that?
Yes, ma'am.
And you understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
All right. As to the charge of criminal trespass, Mr. Beasley, how do you plead?
Guilty.
I accept your guilty plea. That concludes your case unless there's something additional from your attorney or the state.
I just want to clarify, Your Honor, that both of these are time served, balance suspended pleas and not probation.
That's my understanding.
Yeah, I just wanted to clarify it. Okay, thank you.
Yes,
All
balance
right.
suspended.
Thank you, Your Honor.
All right, best of luck to you, Mr. Beasley. Who do we have next?
Thank you. Y'all have a blessed day.
Next, we have position 13 or 14.
I thought 14 bonded out, no?
Well, this is probation.
Oh, probation. All right, Officer Harris, are you present?
Yes, Your Honor, I am.
All right, good to see you again. Okay, let's see. Hold on.
Camera.
I apologize. My phone is doing something interesting. Okay, so sir, your case is 23CR005196B. That's your underlying case in which you were charged with obstruction and criminal trespass. You also have a probation violation. I am going to listen to Officer Harris to give me a recommendation as to how to resolve your case, and then we'll make a decision from there. Who represents him? Do you represent him, Ms. Adams?
I do, Your Honor.
All right, wonderful. Officer Harris, your recommendation?
Yes, Your Honor. Mr. Smith was sentenced on August the 31st, actually, of this year to complete 6 weeks of anger management
He has 270 days left on probation. Our recommendation is to continue him on probation and enroll into the classes within 14 days upon his release.
Okay. And Ms. Adams, do you have any response to that? I'm inclined to allow him to continue on probation.
Your Honor, the only request that we have, because other than that, no, there's no objection. The only request that we have, and I'm not sure if now is the appropriate time. He is financially having a difficult time, Your Honor. So we're just gonna request that his probation fees be converted to community service.
Because he has to do it. What was the classes he was supposed to take again? I'm sorry, Officer Harris.
I ain't
Is there-
doing management classes, and he owes restitution. But we can't convert community service.
I didn't think so. Yeah, I didn't think you could. I would have to either waive those fees. He's taking a class that he how long? He's taking 8 weeks of anger management?
6, Your Honor.
6. I will waive 1 month of fees for him, but otherwise he is gonna have to complete those requirements, okay?
Yes, Your Honor. I just want to make sure I understand. It's not the classes or any of the other requirements. It's only, and aside from the restitution there, I believe there was also a fine associated with his case, and that was what we were requesting to be converted.
Oh, you wanted to convert the fine?
Yes.
Did he have
I
a
don't-
fine? So
No,
I
Your
didn't
Honor,
hear a fine. Yeah,
I don't see a fine either.
I didn't see a fine on his case. I think it's the restitution you're saying, which I can't convert.
Right, which he understands, because I did explain that to him. I just want to.
Okay. All right, sir, you're getting a second chance. I am going to allow you to continue to probation. You must report to probation by Monday. We'll just say on Monday because they're closed the rest of the week. All right?
Okay. Okay, Your Honor. Thank you.
All right, that's the luck for you. That concludes your pay.
Okay.
All right. What do we have next?
That concludes my business, Your Honor. May I be excused?
Yes, you may. Take care, Officer Harris. Have a good afternoon.
Am I sending everything to Ms. Grace?
Yes, please. Please don't send it to me individually. You'll never see it again.
Have a good day.
Okay.
Miss Strong.
I'll send it to Ms. Strong. Please send it to Ms. Strong.
Yes, Ms. Shaw, I have you. Thank you.
Thank you.
All right. Mr. Howard,
go.
you have information for me?
Yes, Judge. I just got off the phone with Destiny at Whitfield County Sheriff's Office, and she confirmed that Mr. Shaw was in custody with them from September 15th, 2023 until 10/28 of 2023.
Okay.
All right.
I'm sorry. I didn't mean to cut you off at medical. Was there an announcement? It's muted. I can't hear.
I'm sorry. No, I was just saying, if we can go to courtroom 2 or somewhere else until we grab the other 2 from 3.
Okay. We're going to take up this. And the only positions we have left is 10 and 11. 10, 11, and is that it? 10, 11, 28, and 29?
Yeah.
Is that all that remains on this calendar?
And Your Honor, you said you wanted to see 42.
29 is a waiver, Judge. So there's no, I'm gonna submit a
Okay.
written waiver for him.
All right, we'll take something else up while you walk with the phone. Thank you. All right, we're going to take up the case of Mr. William Shaw on the DV bench warrant case. Mr. Shaw, your case is 23. Please turn on your camera. I saw you here. Mr. Shaw, please turn on your camera quickly. All right,
Yes.
your case is 23 CR 00310. C, in that case, you were charged with battery family violence, and you now have a bench warrant out for failure to appear. Your attorney has advised me that you were in custody at that time, which explains your FTA. Ms. Allen, is this your case? Based upon the information that you've received from Mr. Howard and that I received as well, I'm inclined to reset this defendant further notice as he could not have appeared due to his incarceration. However,
Absolutely.
Mr. Shaw, you must keep your address current with the court and you must appear when you are rescheduled for this matter, okay?
Yes, Your Honor.
All right, so we're gonna set aside that bench warrant at this time. And if there is an offer on his case, Ms. Allen, if you would convey that to Mr. Howard at some point.
Yes, I think we have it, Judge. We'll need time, obviously, to review it.
Of,
and discuss
of
it.
course.
Mhm.
I wish code defendants would, I understand it, but I also wish you all would do something different with that as well. If I ran this court, there'd be a lot of things different. All right. Take care, Mr. Shaw. Best of luck. Keep your address updated with the court, okay?
All right, thank you, Your Honor.
All right, take care. And we're back on hold while we wait for. Okay, can we do the position 29? You said is a waiver, Mr. Howard?
Right, we're gonna submit a written waiver for that, so there's no, we had.
There's
put an
nothing to be
announcement-
done there.
Right,
Okay.
Not to bring him.
28, what is our announcement?
I believe Mr. McLean indicated he was released. Is that correct? Mr. McLean, Tariq Murphy?
28. 28 was released to Tariq Murphy.
Okay, so 28 has been released. So we're not doing that one. Ms. Strong, do you, since we only have 2 positions that we're waiting on, or maybe 1, do we want to review the calendar now?
Actually, Judge, there is another position that we can address if you.
Okay.
I and Miss Allen can go into a breakout to address position 42. That was reset from the other day. I think the judge may have left you some notes about that, Judge Williams, about that case. We had reset it from Thursday's competency calendar.
All right, the announcement I had is that one is transferred to the DA's office, Mr. Howard.
Position 42?
Jacon Ward, Mr. Ward.
Oh,
Is that,
okay.
so it's been upgraded and transferred. We can still go into a breakout if you want, but I don't think there's anything we can do there either.
Yeah, if we could. We were not made aware of that. Yeah.
Okay, we can go into a breakout briefly with Ms. Casadakis and Mr. Howard.
And if you could include Miss Allen also.
Yeah,
Oh,
Miss
and Miss
Allen.
Allen and Miss Allen.
Because I'm sure Miss Falk left her plenty of notes about this one.
Okay.
By the time we get back, hopefully the other people will be here.
They updated the announcement.
Why she said it's supposed to be great?
Hold on. Okay, so.
He's gonna go with Thomas thing? You go down, right? I'll take the people first. They said that doing I'll call on this person.
All right, we're in medical. We have position 9 and 10. Mr. Green.
Mr. Maddox.
Ms. Adams, is anyone there with you at courtroom 2? Who's there with you at courtroom 2 from the jail staff?
Yeah, Deputy Francois is here.
Oh, Ms. Francois, Deputy Francois, can we ask you a question?
Sure.
Mr. Ward has been taken to Grady and his father would like to be able to get in contact with him. Do you know what we can do or how he can do that? How can he get in contact with Mr. Ward? Do you know?
You said he has to go to Grady?
He has to put some vote Grady.
He's at Grady.
He is at Grady, Nora.
He's at Grady.
That's our understanding, yes.
Nora, they're saying that he's already at Grady.
Oh, I don't know exactly what room he's in though. All right, cool, but
If you don't know, that's okay. His father said he plans to probably come down to the jail and ask more questions, but we know he's not at the jail. He's at Grady. So, if you have any, do you have any insight about what his father might be able to do?
Yeah, he can come to the jail and reception, they can,
Help him.
direct
Okay.
yes.
All right, Mr. Maddox, the best thing for you to do is come to the jail and somebody at reception will try to assist you, okay?
Okay, thanks, Your Honor.
All right, take care. Have a good afternoon. All right, who do we have at medical? Is this Mr. Green?
Yes, position 9 and 10.
And 11, correct? All right, Mr. Green, you're here for 3 cases, 23 CR 006907J, in which you're charged with simple battery family violence, 23 CR 00802J, in which you're charged with simple battery as well, simple battery family violence, and 21 CR 00730J, in which you're charged with disorderly conduct and simple assault. Do you understand, right?
Yes, ma'am.
All right. Ms. Casadakis, will you please give, oh, I'm sorry, what is the announcement for this case?
My notes say 9 is a negotiated plea, and then 10, 11, it says conflict, so I'm not sure.
Is this Ms. McLeod's case?
Yes, it is, Your Honor.
Ms. McLeod, are you still with us?
Yes, ma'am.
Yes, Your Honor.
All right, I'm sorry. Do you have an announcement for Mr. Green?
Yes, Your Honor. The state had made an offer to resolve all of Mr. Green's cases, Your Honor. I haven't had a chance to speak with them yet about it.
Okay, can Ms. McLeod go into a breakout with medical? Ms. Grace or Ms. Strong, will you put Ms. McLeod in there? Ms. Strong, do you hear me?
I'm doing it, Judge.
Thank you. And will you review the calendar for me while we wait?
Sure. Position number 1 and 2 were negotiated plea. I think I missed what happened with position number 3, or were we still waiting?
3, I don't believe his attorney is going to appear, so we're going to reset to SAP. Which day is the least full? Put it on Tuesday if it's room on Tuesday. Put reset Tuesday.
Okay.
Thank you.
Sorry, I lost y'all. Give me a second. Okay. Position number 4 was a negotiated plea. Position number 5 was an amended bond. A $2,000 signature bond through the jail to be released to where Miss Adams was supposed to be sending me in the chat.
I did. You didn't receive
Position
it?
number 6 was a negotiated plea. Also, Mr. DeBose's case 23 CR 004. I'm assuming that was 448J, 23 CR 006 622J, and 23 CR 006 623J were all negotiated pleas. Position number 7 is reset for December the 7th competency calendar. Position number 8 was a negotiated plea. Position number 9, 10, 11 are the cases that we're waiting on. Position number 12 was arraigned, not guilty, reset jail jury. Position number 13 was arraigned, not guilty, reset jail jury. Position number 14 was released. Position number 15 was transferred to Superior Court. Position number 16 was waived arraignment, reset jail jury. 17 waived arraignment, reset jail jury. Position number 18 was transferred to Superior Court. Position number 19 was a negotiated plea. Position number 20 was null pros. 21 negotiated plea. 22 was null pros. Position number 23 was released. Position 24 waived arraignment, not guilty, reset jail jury. Position 25 waived arraignment, not guilty, reset jail jury. Position number 26 was a negotiated plea. I don't have 27. 27.
Okay, hold on.
27 was reset.
So
It was reset requested by the state. The judge.
Have reset 11/28.
position number 28 was released. Position number 29 waived arraignment, reset jail jury. Position number 30 was reset for November 30th SAP calendar. Position 31 and 32 negotiated plea. Position number 33, 34, 35, 36, 37, 38, and 39 will be reset for November the 30th competency calendar. Position number 40 reset for November the 30th competency calendar. Position number 41 was a negotiated plea. Position number 42 was transferred to Superior Court. Position number 43 waived arraignment, not guilty, reset jail jury. Position 44 transferred to Superior Court. Position 45 not guilty, reset jail jury. Position number 46 not guilty, reset jail jury. And Mr. Beasley's other case, 23 CR 004-694E was a negotiated plea.
Any comments, corrections, changes otherwise?
Not from the defense, Your Honor.
All right, hearing none, we
I
will
have a
be-
quick question.
Uh-huh.
Just briefly, one of the first cases that was announced was a release. My notes said that they'd been loaned out to Chatham County. Number 14, Mr. Hampton.
Yeah, Mr. Hampton was originally loaned out. I wasn't able to meet with him last night, and we found out he had actually been released.
Okay.
I'm sorry, Miss Adams, we couldn't hear you. You said that he was not released?
No, I said he was originally loaned out to Chatham County, and then he had been released.
Okay. Understood.
Thank you.
Yeah, no problem.
Miss Allen. Mr.
Yes, ma'am.
Body's FTA number, so I can get the non-personal.
Oh, wonderful.
It's 23
Mhm.
FTA 001-046.
I'll send that to you now, okay?
No, not the trees. About 1,000. 2 weeks. Almost.
Ms. McLeod, your announcement?
Yes, Your Honor. My client wants to take a plea, and it seems like it's going to have to be non-negotiated because there are a couple of terms which the state has, which my client doesn't agree to. And that is the no contact and the stay away.
Okay. And you've explained the, okay, well, let's go through it. Is the alleged victim on the line today?
I think she's gonna come on. I contacted her, I spoke to her. I think that may be her connecting to audio at this time because she did tell me she was at the doctor's office.
All right, let's first hear the history from pretrial. Is pretrial on the line?
Yes, who is this again? I'm sorry.
Walter Green,
position
Green.
11.
One moment. Okay, looks like Mr. Green, he has 4 arrest cycles beginning 2021. Let's see. It looks like he has a disorderly conduct from 2021. There's no disposition listed on the GCIC for that case. And it looks like the 2 cases that are on the calendar, and his last arrest was for felony willful obstruction and simple battery against a police officer. That arrest date was 30th of 2023. No disposition is listed on the GCIC for that case. And it looks like he has 1 cycle out of Alabama, and that's from 2004, and that was for harassment, crimes against a person. No dispositions listed, Your Honor.
All right, thank you. Ms. Katsoudakis, this is your case?
Yes, Your Honor.
Please proceed.
All right. Case number 22CR006907J. The defendant punched Laura Gibson, who was his girlfriend and was living at the household at the time of the incident, on top of her head multiple times. The state's recommendation is 12 months probation, serve 126 days, credit for time served 63 days, balance probated, ADET, no further contact with Laura Gibson, and stay away from the address 1605 Stokes Avenue. That's for the first one. The second case, 23CR000802J, battery family violence. The defendant made physical contact of an insulting and provoking nature with Antonio Chambers, a person living in the same household at the time of the incident, by striking him. The state's recommendation is 12 months probation, serve 60 days, credit for time served 8 days, balance probated, no further contact with Antonio Chambers, stay away from that same address, 605 Stokes Avenue, FVIP, 40 hours community service, consecutive with 22CR006907J. And then position 11, case number 21CR007300J. That's, let's see here. The disorderly, he stated he would place a bomb in the victim's Laura Gibson's residence and broke a lamp. And the simple assault, defendant placed the victim in reasonable apprehension by swinging a bat in her direction. The state's recommendation on count 1 is 12 months probation, serve 6 days, credit for time served 3 days, no further contact with the victim, Laura Gibson, balance suspended, stay away from the same address, 1605 Stokes Avenue. Count 2, 12 months probation, served 6 days, credit for time served 3 days, no further contact with Laura Gibson, stay away. Oh, balance suspended, stay away from that same address, concurrent with count 2. And this is a global resolution recommendation, Your Honor.
Okay, and Ms. McLeod, you've indicated that the points of contention are the contact and stay away. Ms. Gibson, if you would raise your right hand and turn on your camera, and unmute your screen. I see you on the screen.
We had somebody have though.
Ms. Gibson, I need you to unmute your screen and raise your right hand. You gotta unmute though. I'm not gonna be able to hear you. You're on mute.
I think there was someone there helping her with it. I don't know if she's still there.
I don't know, but we can't hear Ms. Gibson. Someone, you need to unmute. Hit the unmute button. It looks like a little microphone. I can't hear Ms. Gibson. Can you unmute the screen? Is someone there with Ms. Gibson who can press the microphone button?
There was someone there earlier, but she may have left the room.
She's speaking to somebody off to the right. Can you unmute this? All right. Do you swear, Ms. Gibson, that the testimony you give will be the truth to the best of your knowledge?
Yes.
All right. What would you like to tell me today? You can put your hand down.
I'm on the family he have right now.
She said she's on the family that he has right now.
I can hear. I heard her. That's all. Would you like me to know?
Yeah, I think. What else you want me to say?
No, I just wanted to hear what you wanted to tell me.
Yeah, I'm the family that he has right now.
Okay, and you're his mother. What is your
Girlfriend,
relationship?
Your Honor.
You're his girlfriend?
Yes, I think he on his lesson now.
I'm sorry, say that again?
I think he gonna learn his lesson now.
Okay, thank you. All right, Ms. McLeod, please proceed.
Yes, Your Honor. My client he's been in jail for quite some time. I think it's more than 60 days that Mr. Green has been locked up. He does have some challenges, Your Honor, but he and Ms. Gibson have been in a relationship for some time. I have had the opportunity to speak with her many times, and she tells me that she is like his only family that he has, and she wants him to be able to stay with her. And I just wanted the court to understand that they are in a relationship, and she does want to have contact based on what she has told me many times.
All right, Ms. McLeod and Ms. Kostadakis, I'm seeing 3 events involving the same victim. So if he does take this plea today, Ms. McLeod, I'm inclined to follow the state's recommendation and require that he stay away for that time and have no contact with Ms. Gibson. I understand her position and yours as well. Does he still want to take this plea if that's what I require?
I don't think so, Your Honor, but I would have to speak to him again because he really doesn't have anywhere to go. He's going to be effectively homeless because that's the only home he has. Mr. Green is not able to work or anything like that, Your Honor. He has some challenges.
I understand. Do you want to speak to him again quickly, Ms. McLeod?
Yes, Your Honor.
All right. Can we put them back in the breakout quickly?
Your Honor.
Yeah.
Just if I may, position 9 was against Miss Laura Gibson, and then position 10 was Antonio Chambers, who also lives there, and then the third one was against Miss Gibson also. So Gibson had 2, and then the other victim had 1.
Mr. Chambers is Mr. Chambers is Miss Gibson's son, I believe.
Yes. He was a son, and there was a situation where he struck my client. You know,
my son not there no more.
Yes, she says her son is not there anymore.
He moved out. He been gone.
Okay. I'm still inclined to follow the state's recommendation, Ms. McLeod. So would you like to speak to him?
I do need to speak with him, Your Honor.
All right, if we can put Ms. McLeod back in the breakout with medical.
Ms. McLeod, you aware of his felony cases that are open?
I am, yes. Thank you. Thank you,
Yeah.
Ms. Allen. And after I have spoken to him, I also think a breakout room might be appropriate.
Okay. Ms. Strong, can we have Ms. McLeod in the breakout with medical, please?
I'm taking care of it. I got you.
Okay, thank you.
Give me a second.
Your Honor, I was able to speak with my client and I would like us to go into a breakout room.
All right, if I could be placed in a breakout, please, with Ms. McLeod, Ms. Allen, Ms. Pasadakis, I would appreciate that.
Okay, Judge.
Yeah, okay, get on college. Just come to my door. Yeah, not that procedure. 22 minutes. Done.
It's amazing how something as simple as a tree bring people so much happiness. That's why I love what I do. My life's purpose is to literally bring joy to families every Christmas. If I can't do that anymore, you have to wear a jacket. Hey, Jack. Well, wait, I saw a light about to use the one or two years to do it. Oh, no, we're just keep doing scientific research. Is that what they call it these days? Yeah, it really was. Okay, until midnight. As well. Do you recall tomorrow and how it was actual science? Well, yeah. Wish that if the careful, it's a little bit slippery out here. Please, I'm a third generation New Englander. I'm don't say a word. I would never. I'm a fourth generation Tennessee, so. Don't need that. Don't need it. Just let's get this aside. Oh, really? There you go. You can just there for the skateboarding. Nice. Hey, I think there's up morning breakfast. Yeah, that's good. Yeah. Yeah. So then we go fresh up into the sitting next to the tree and staring at it all night. It's perfect. Hope we get the answers. Okay. Make my way through your house, but this is Seattle. She's going to be my home today. Oh, this is beautiful. Oh, it's absolutely wonderful. I can use you in my shop. Good morning. Hey, I'm making some breakfast. Oh, if you're looking for Jack, I overslept a little bit. Yours. Want a cat? Should I put cat? So, some of the favors you do for her, huh? I don't know what you're talking about. I heard Santa was here. Santa was here? If you hurry, maybe you can give me a Christmas list. Why, he already knows my Christmas list. Santa and getting your hopes up or down, so I know for sure. After I pick up my car and bring the samples back to the lab on campus. My equipment is good, but the lab is the best. Great. Sorry. I'm too tired to talk about what I took you. You sure you have time? Yeah, man, until we get this figured out, I got nothing but time. Okay, all the tests are up and running. I just need to make sure I didn't forget anything. Don't take that. No, good. I just want to take a look at my master checklist.
All right, Mr. Green, are you still there with us? We have some additional work to do on your case. So we are going to reset this case. Ms. McLeod is going to be in touch with you. We've decided that there's some additional work that needs to be done. And your case has already been arranged. So it may be that you end up going to trial, but just because we're setting it for trial does not mean that that's what's going to happen. It just means that you and your attorney have some additional investigations to do, and we're going to reset your case for a few weeks, okay?
Yes, ma'am.
All right, Mr. Green, you take care. Best of luck to you. All right, we have concluded the SAP calendar. Take care, everyone. We've reconciled it in full. If you would please send all orders to Ms. Strong, we would appreciate it.
I'm sorry, Your Honor, we do have one more. We have position number 40.
We do? Okay.
Thomas Sherrard.
That was reset to 11:30, Your Honor.
Okay, that case is, Mr. Sherrod is being reset.
Okay.
All right, thank you. SAP is now complete. Mr. Sherrod, your case is being reset if you're listening.
Judge, when you figure out what your thing, just let me know, please.
Okay, will do.
Ms. Strong, before you go, I just wanted to find out whether or not you received my check, because I did send you a chat with the information for Mr. Chanel.
All right. I'm leaving. Take care, everyone. Bye-bye.
I'll email it to you when I send off the paperwork.
Thank you, Judge.
Casey, what are you looking for?
What the name of the place that this man was supposed to be released to?
Yeah, I'll email all the information, address and all, because I did send it to you in the chat. I don't know why you didn't get it.
I have it, Casey. I'll write it down for you. She sent it to me.
I sent it to you by accident? Okay.
Yes, that's okay. I got it for her.
All right, thank you.
We gotta figure out what day. I mean, I gotta, it may not be Monday, it may be, because I think transport may need more. We'll send it, but I want to verify.
Okay, all right.
I'm saying that.